Ladies and gentlemen, and welcome. I want to say before I really get going, we are going to be tape recorded, video recorded. Jack Wyatt is over there. He will do that, so you're going to be on the internet. If you want to look at it later on, go to the town website, click on channel 18, and then you can click on their YouTube webpage, and that's where this and indeed all meetings are now. So when I invite the public to speak, if you're going to speak, please come to the microphone at the podium. Speak clearly so it's picked up on the video, introduce yourself, and name and address, and then you can say whatever you're going to say. Okay, welcome to the Zoning Board of Appeals public hearing. This Wednesday, November 29th, 2017. We've opened the meeting at 7 p.m. here at the Griffin Meeting Room, Harwich Town Hall. We will hear the cases that will be read by our clerk one at a time. At the appropriate time, I will invite the public for any input they may have on each case. I want to welcome, we have three new alternate members, Mr. Dan Tworek, Mr. Michael, I've got to see, I don't know Mike, Mr. Michael Capoli, and Ms. Megan Mayhew. Got that one, okay. So welcome, and we're going to start with Dan introducing the board members, please. Just introduce yourself, yeah.
Jim Hilliard.
Kathleen Muller.
Dean Hedderstedt.
Dave Ryer.
John Burke.
Al Donahue.
Mike Capoli.
Megan Mayhew. And Sheila Delaney, secretary.
Okay, I will have the clerk read our first case, but before we do that, we have said from the outset when 2017-18 and 2017-19 first appeared on the agenda that we would handle the two cases together because the subject matter is essentially the same. We'll do them individually, but we're going to have the board members that were present at the first hearing of 2017-19 be the members that hear 2017-18. And that would be, let's see, Mr. Donahue, Mr. Burke, Ms. Muller. Wait a minute. That only gives us three. And, I'm sorry? And me. That's right, and me.
Mr. Hedderstedt had recused himself.
So that would be a four-member voting board on these two cases. I'm going to Mr. Hedderstedt has recused himself from these cases, so I'm going to ask him to take a seat in the audience, please, until we deal with these two. Okay, Mr. Burke, if you could read the case, please.
Yes, good evening. Case number 2017-18, which has been continued from November 29, 2017. Petitioners Jeffrey Rigo and Joseph H. Rigo III, through their agent, Attorney Charles Sabat, have seek a decision of the board overturning the building commissioner's denial of a request for enforcement under MGL Chapter 48, Section 7. Applicants contend that their operation of a sand pit is prohibited under Section 325, Table 1, Use Regulations, and/or requires a permit under Section 325-102, and that travel to access the subject pit over a private way, a portion of which is across the applicant's property, is an unlawful extension of an unpermitted industrial and commercial use into into a residential zoning district in violation of Massachusetts case law. The property is located off JZ Drive, Assessors Map, Miscellaneous Parcel 4054001 in the RR zoning district.
Okay, I see our building commissioner, Mr. Chesley, in the audience. If I could have you come up, Ray, please, and sit with the board. And just for the record, if you could introduce yourself, please.
My name is Ray Chesley. I'm the building commissioner here in town.
Thank you.
Mr. Chairman, before Mr. Sabat begins his presentation, I represent the Lewis family on the 19 appeal that was heard initially on July 26th. My records show that the members of the board then sitting was a gentleman named Franco Previd. Is he here tonight?
He has resigned from the board.
because I want the same 5 that heard the first part of the appeal.
Okay, that's not possible because he has resigned. He's no longer a member of the board.
I don't, if I may, I'm not certain that you opened this hearing on my case.
Correct.
You may have opened it on the second one.
We opened it and granted a continuance.
All right, okay.
And another point of order, the chairman indicated they wanted to hear both appeals together. I object.
No, not, I meant the same, I misspoke, I'm sorry, I meant the same members voting on both cases.
Well, my dilemma now is how I'm going to get the same 5 people that I had on July 26th, one of whom doesn't exist anymore,
Well, you're
is
not.
a board member.
You're not, because he's resigned from the board. And unfortunately, that meeting was not taped, because I did ask Mr. Hilliard if he would look at the tape, but unfortunately, that was before the meeting started to be videotaped, so there was no way for him to really review the record to see what transpired in the first hearing.
So then, in essence, I've got to start all right from the beginning, as though July 26th never happened, because the board is going to be constituted in a different manner. Is that what's happening?
One moment, let me confer with Mr. Burke.
Yeah, if he would like a 5-member board, which I'm assuming that he would.
Right.
We can start from scratch and appoint 5 new members, right? And I would suggest you do that.
Okay,
And,
that's reasonable. We will let you restart your case, Attorney Shealy, and we will have as voting members Mr. Hilliard, Ms. Muller, me, Mr. Burke, and Mr. Donahue.
Okay, fine.
And we will have those same 5 members on case 2017-18. So you will each have a 5-member board.
I just have one more point of order, and it relates to Mr. Sabat's presentation tonight. And this is for the record. I'm going to object to Mr. Sabat's hearing being held tonight. The reason is that, in my opinion, under Chapter 48, Section 10, there is a statute of limitations on challenging the special permit that issued in 1973. That's a 10-year statute of limitations. This appeal was filed in 2017, and when you read the statute, it talks about appealing special permits and variances and gives a 10-year statute of limitations. So for the record, I'm objecting to that hearing going forward based on the fact that this board has no jurisdiction to hear an appeal at this late time on a 1973 special permit, which is exactly the petition that would be before the board this evening.
Okay, so noted. If you could identify yourself,
Yes.
please, for the record.
My name is Charles Sabat, and I represent Jeff Rigo and Joseph Rigo, who are abutters on a private way known as JZ Drive in Harwich, Massachusetts. And what I wanted to do is to, first of all, begin to clarify what it is that I am appealing from. The appeal that was filed in this matter appeals from a denial by the building commissioner to take any action on my request for enforcement. The building commissioner obviously did take action on my request for enforcement, which led to the second case. What happened was, it was sort of like a funny thing happened on the way to the forum. Interestingly enough, it indicates on the cease and desist order, it copies me. Charles Sabat, CC, is listed on that list, but I never received a copy of the cease and desist order. So obviously the building commissioner intended to notify me. For whatever reason, it didn't occur. Not a criticism. You know, it could have been lost in the post office. Maybe it didn't get out. Maybe I lost it, but I didn't receive it at my end. So I then, in order to preserve my rights under this statute, you have to act within X number of days, 30 days from having made the request, unbeknownst to me, that the cease and desist order had in fact issued. In terms of the sand pit, I filed this broad-based appeal. However, one of my issues remains alive. And I am appealing, so I'm withdrawing so much of this appeal as applies to the request for enforcement with regard to the use of the sand pit, because obviously the building commissioner acted as I had requested with respect to that question. He declined to act, as he says in his cease and desist order, with respect to the use of the way that leads into the sand pit, and particularly in my case, of what's interest to me with respect to the use of JZ Drive. And that is what I would like to address tonight. And I'm appealing from that portion of the building commissioner's decision, if you will, or declination to act on that part of my request. And then I would address with you at the end of this one of two things that you could do, because obviously, depending upon how you rule on the next item, the next matter that comes before you, and it so happens that that's on the, mine got the earlier docket number, that's why I'm here first, but depending upon how you rule, may have an effect on what you ultimately would decide with respect to this appeal, because obviously if you uphold the building commissioner and determine that the use of the sand pit as it is currently being used is in fact unlawful and violates zoning, then it in many ways may render the rest of this issue, namely the use of JZ Drive, somewhat moot. But having said that, let me just explain to you what my issue on that particular part of this is. As you will hear in the second matter, the individuals who claim to have an interest in this pit, namely the Deleuze family and others, are using an area that is west or northwesterly of Eldridge Pond for a sand pit operation. And as the building commissioner correctly points out in his letter, there are some other activities that they're engaged in out there, apparently some wood waste recycling activities. There's also some reclaimed material that was being worked on out there. And it's an active commercial industrial type of use sand pit, which is completely prohibited under the bylaw in that particular district. And it is in the Six Ponds district, overlay district, among other things. In order to access this sand pit, the various users of the pit, to whom the building commissioner addressed his letter, namely Barrows Excavating, J. Brown, Inc., and Clifford Deleuze, John Deleuze, Robert Deleuze, and Margaret Weigand. All of these individuals, in one form or another, are running heavy equipment over JZ Drive in order to access this pit. There is a proposition of zoning law in Massachusetts that I have referenced in the appeal, and I have some copies of the decision for you, which provides that the owner of an industrial site, assuming that in fact the Deleuze's have the ownership, let's call them the users of the industrial site, in this case the sand pit, may not use land located in a residential district as access to an industrial use. And the two cases for that are a 1978 decision of the Massachusetts Appeals Court, which is Chelmsford versus Byrne, and that case states, just as I've said, an owner of land in an industrial district may not use lots of land in an adjacent residential zone as access roadways for its industrial use. There is an earlier decision from which that grows out of, which is the lead case, which is Harrison versus the building inspector of Braintree. And this was a similar circumstance where an industrial corporation that was engaged in some heavy manufacturing was using land located in a residential district as access to its industrial use. And again, the court stated, and this court was in fact the Supreme Judicial Court, the use of land in a residential district in which all aspects of industry are barred for access roadways for an adjacent industrial plant violates the residential requirement. So in this particular case, what's occurring is that these people are using a private way. They're not using a lot or land, so you could in fact distinguish it from those cases. But my position is that the principle is the same. JZ Drive is a private road, not a public road. There is a case that's pending on that matter now in the Barnstable Superior Court, which I'll touch on briefly in a moment, where the argument is being made by the Deleuze's and by some of these others that JZ Drive comprises part of what's known as an ancient way. That doesn't necessarily make it a public way. JZ Drive is still private. It was authorized and approved by the Harwich Planning Board as such. And there are, in fact, some easements that are granted to some specific individuals there. I'm not asking this board to make a decision about what's pending in the Barnstable Superior Court. That case involves whether or not any of these individuals, namely Barrows, Deleuze, and the others, have any legal right to use JC Drive. That's not the decision that I'm asking this board to make. That's well beyond what your business would be, and I didn't ask the Building Commission to make that decision. My focus is more narrow, namely on the zoning aspect of that use. And what I'm submitting is that under these cases that I've cited, that where these individuals are claiming to have an interest in JZ Drive in the form of some kind of an easement or some kind of a right to cross and recross, it is similar to claiming an ownership interest in a lot, which is what the Chelmsford case applied to and what the earlier case applied to. And so it's the same sort of situation, namely that we are using a private roadway in which these individuals claim to have rights of access, private rights of access, as an access into a heavy industrial use. And so what I requested the Building Commissioner to do is not only to order a cease and desist of the pit itself, but also to order a cease and desist by these individuals of the private way as an access way into this industrial use. That's the narrow focus of the appeal that I have brought and that is now before you. And I don't know whether I submitted, I have copies of the plans of JZ Drive. I can't recall whether we submitted that in the original package, but I can provide you with some of, I have 5 or 6 of these copies that I can provide you with anyway. If you'd like to take a look at it.
Do we have these already?
I'm sorry?
Do we have these already?
I'm not sure whether they're in the package or not. I'll provide them to you.
2004. We have these.
Sorry.
Okay. Even here, now that it's open, it saves me from opening it.
Does anyone else want? So that in essence is this part of the appeal, and I suspect that what will be contended here is that there is a case that's pending in the Superior Court. In fact, I provided the Building Commissioner with a copy of that complaint. I provided it to him so that he could see the statements that had been made by the plaintiffs in that case, who are the Deleuze's and Barrows and so on, in that case, in which they talked about the types of heavy industrial uses that they are putting into effect on this JZ Drive on the private way, and they're still doing it. I mean, the cease and desist order is out there for this sand pit operation, yet they are still operating there. And my clients would tell you that these trucks are going up and down that roadway on a regular basis. They're completely disregarding the cease and desist order that's been issued, and they're continuing to operate. And one of the things, for example, that they allege in this complaint is they say that as part of his operation, they're referring to Robert Deleuze, he utilizes an 18-wheeler and a large mobile dirt shaker sifting machine, which is something that you would use in waste recycling. You sift out the sand and the debris from the wood waste, namely logs and branches and so on, and then you process it through a grinder to produce loam. And they contend in this complaint that this is his sole access into the Deleuze sand pit. And they also refer to Robert Deleuze doing business as M&M Trucking, and is in the business of trucking aggregate products, including but not limited to dirt, sand, and rocks, and so on. So these trucks are going up and down this residential roadway on a daily basis, and that's the whole point of setting up residential districts, is to prevent industrial uses of this nature. If this was a public road, it would be a different scenario, but this is private, and these people are claiming to have interest in that road, and they may well have them. That's for another day and another place, namely in the Superior Court. The question here is whether under zoning they can in fact continue to operate there. And one of the things they say in this complaint, which I'll mention when I address you on the next one, is this complaint, by the way, which is signed and verified by the Deleuze's, there's a verification here, which they verify the facts in the complaint. They say that the sand pit, and that will be the issue in the next hearing as to just what sand pit are we talking about. The sand pit has been in existence at least since 1973. So they've said this to the Superior Court. So we know that that's the pivotal date that we're starting at by their own contention. But that again is for the second hearing. With respect to Mr. Shealy's point that he raises about this 10-year statute, we are not appealing from or appealing the 1973 special permit. That's not what is before you in my appeal here on this limited issue with the Jay-Z Drive matter, nor was it the subject of my letter to the building commissioner. What I was appealing, what my clients are appealing, in addition to the use of this roadway, is the use of this land in the Six Ponds Overlay District, in a residential zoning district, that has no license whatsoever, no permit that's in effect right now whatsoever. It's the use that is currently in effect. That's what we are appealing from, not from the 1973 decision. And that's what the building commissioner addressed in his cease and desist order, with what's happening there today. The 1973 decision, I raised it to the building commissioner and brought it to his attention only because and I said in the letter, I'm unclear whether or not it even applies. It was unclear what parcel it applied to and so on, and I think he reflected that in his letter, in his cease and desist order. I would infer that he came to a similar type of conclusion about that. So this is not an appeal from that, and any statute of limitations issue doesn't pertain here at all. We're talking about something entirely different, which is a use that's been implemented recently, and I think you'll see when you get into this second hearing that this is an entirely different scenario than what existed in 1973. So there's no appeal from that particular permit to the extent that it still remains in effect. So what I would ask you to do, and I suppose I will present you with two options here, but what I would ask you to do is, in the first instance, is to overturn so much of the building commissioner's action in his having declined, as he says in the cease and desist order, to take any action with respect to the use of Jay-Z Drive and the road that runs north of Jay-Z Drive. And the other option that I would present to you is that, given the fact that this dovetails out of the second hearing, the one that's coming up here, your other option would be to continue this matter generally. In that way, my rights are preserved, and we can look at this issue at a later day in terms of any appeal. But so, in the first instance, I would be asking you to render a decision appealing from so much of the building commissioner's decision as to decline to take action with respect to Jay-Z Drive and the road that runs north of it, the roadway running north of it, or in the alternative to continue the matter generally pending the outcome from the second hearing. I have copies of those decisions that I could provide to the board as well. And obviously, I can answer any questions that you may have.
I guess my inclination is I don't want to continue this to another date, but I would be willing to continue it until we hear 2719 and then revisit this case. Mr. Clerk?
How do you agree?
I think otherwise, we're going to waste a lot of time here. I think we should go to the 2017-19, and then we will revisit this case. Do you want to do questions? Do you want to do?
I think we should do the first round of questions with council first.
Okay, we'll do
and
the
then-
first round. We'll start over there with Mr. Tworick. Any questions? Mr. Hilliard?
Yes, thank you. Not to oversimplify it, but what you're asking the board to do is to rule on the issue of whether or not, as a matter of law, this JZ Drive, which probably irrelevant as to who owns it, may be used in the manner it's being used, and that is a residential way abutting a business way, and that it shouldn't be used under the case law? Is that what you're referring to?
Right. I'm asking you to rule that this may not be used as an access way into an industrial
As a
use.
matter of zoning law?
Exactly,
Okay.
exactly.
And is that the same issue, or one of the same issues you have now before Barnstable?
No, the issue in Barnstable is actually a little bit, is different.
Okay,
In
I
that-
don't want to know, as long as
Different.
the answer is no, okay.
To be fair, it involves, it's an argument about who has rights in this roadway. But the zoning portion of it is not,
Okay.
in that particular case.
Would you agree then that the ownership of JZ Drive is really not relevant?
I agree with that, right. It's a private way.
Yeah.
No, I mean, I could give you my, in my opinion, as a footnote, sort of, that it probably is owned by each of my clients, given the description of their deed. They may own to the center line of that way, each of the abutters on this way, and there are specific easements that were granted to two individuals, if you look at the deeds. And the other individuals, as I've said, are claiming that they have rights through various forms in this
But
section.
no one who purports to have ownership in this road has either commenced litigation or commenced with any kind of a demand to cease and desist use of a road that they have ownership rights in?
Well, I would say my clients, to the extent that they do. I haven't really, I'm a little bit on thin ice because I haven't really looked at that part of it. There's somebody else that's handling the litigation part of that case, but just from what I remember of their deeds, they're certainly abutters to that way. It's a private way. I would say, given their deed descriptions, they may well own to the center line. I don't have it in front of me. I don't want to commit to that 100%, but I think if I went back and looked at it, I think that's probably what I would find. So I couldn't say with exactitude tonight that they have a fee interest in it. I suspect that they do. They certainly are abutters on the way.
Thank you.
Ms. Muller?
No questions at this time.
Mr. Chesley, would you like to say anything?
No, no comment.
Again, I guess my point is, I think the issue is whether or not the special permit is valid or not, and whether they have the lawful right to operate the pit. I think the road issue, eminent domain or whatever, that this board is not going to address. So I think your case rises and falls on the permit case, and the access road, I don't think is a subject that this board should address, my personal view. Mr. Burke?
I have a question. I think Mr. Hilliard kind of framed it, and I agree. The very narrow issue in this case is simply whether or not, under the zoning bylaw or under Massachusetts case law, they are permitted to use this roadway. to
As access to their industrial site, yes.
That's it. Are you citing any part of the Harwich zoning bylaw as authority for the premise that they may not use it?
Well, the only part that would be applicable would be that this is a residential district. So there's no specific provision that, to answer your question, that says that, thou shalt not use a private way as an access way into an industrial site.
So the basis of your legal argument is the Chelmsford and the Braintree cases?
That is correct.
Now, a question for you then. In the Chelmsford and the Braintree cases, you have residentially zoned property
Correct.
accessing industrial or commercially zoned property?
That is correct, Jim.
Okay. In this case, that's not the case.
That's right.
This property is entirely zoned residential front and back,
That is correct.
and that the usage, if it were legal, is by special permit.
That would be correct, but I would go a little bit further, and I would say that the concept is the same, namely that it's an industrial use, even though it's in a residential district. And I would go further and say that if there is a special permit that allows the use as it occurs today, then they would also need relief in order to have JZ Drive and the road that runs north of it as their access way into that industrial use.
That doesn't make sense to me, that if the bylaw permits a particular non-residential use in a residential zone,
Yes.
that it would not permit the use of residential streets, private or otherwise, to access it.
Well, I think that you would have to, in the permit, let's say that there were let's take the 73 permit away for a moment. Let's say that somebody came in today before the planning board, because I think that's the permit issuing authority under the current bylaw for an operations permit. But let's say they came in here for a special permit, whatever it may be, and they said, we want a special permit to have a sand pit in this residential area. And one of the questions that you would be asking, I think, is what is your access into that industrial use in the residential area? And if they responded by saying, well, it's over JZ Drive and it's over these private ways and we're going through these residential areas to get to this, I think that it would be, that they would be required to ask as a form of their relief, not only the right to use the specific site, but the right to use this private way as an access road.
That might be within the discretion of the permit granting authority relative to conditions in a special permit, but
Right.
what you're saying is that as a matter of law,
That's right.
this road can't be used to access that on the basis on which you're citing cases that say you were going through residential zones to get to industrial zones, which is not the case here. I
It
guess
is-
the question is, how does Chelmsford and Braintree shake out on that distinction? That's different than this.
Well, the rationale
Yeah.
in each of those cases is that it's not just that you're going into into an industrial zone, but you're using this as access to an industrial use. That's the rationale. In other words, that you cannot extend an industrial use into a residential zone. Now, I understand what you're saying. We're not really extending anything. We're allowing an industrial use within the residential zone. But the concept is exactly the same. Namely, you have an industrial use, whether you've allowed it by special permit or otherwise, and now you're allowing it to be expanded over a private way that runs through a residential area as the sole access way into that industrial operation. So the rationale is exactly the same.
But that's not the case, I think it's Mr. Burke's point.
Well, I think he's
So the
right. I mean,
authority is.
I get his,
Yeah,
I get his
the authority-
position, and I'd be interested to read the case. That's all,
Right.
that's the only questions I have. Thank you.
Mr. Burke. I'm sorry, Mr. Donahue.
The properties along J.C. Drive, J.C. Drive was not there, so this roadway pre-existed the development on J.C. Drive.
as far as I know, the roadway appears to have been there
It's an
prior to.
ancient access to
Yes.
this property.
Yeah.
I don't have a picture.
Yes, in Harrison v. Building Inspector of Braintree, the exact language was, may use lots of land in
Right.
the adjacent residential zone as access roadways for its industrial plant. You contend that JZ Drive is a private way. The SJC stated in Note 2 that they did not, this petition did not enable them to give significance to a number of roadways whether these private ways for limited access would apply.
I think what they're saying there is that, they don't know as a fact. What they say is whether these are private ways for limited access does not appear. In other words, what they're saying is they don't know whether these private ways have limited access. I think that's what they're saying. They just don't know what the facts are.
Right, so, referring back again to my previous quote where they open the case on page 559, use lots of land. So
Right.
I think that differentiates this case because you're trying to say that this is not using lots of land, but rather a
Right.
private way. So do you see that differentiation?
What I said earlier was that I agree with that those cases are talking about that these industrial owners, users, took land that they owned in the residential areas, and they created an access way. And they happen to have had what we call a fee interest. They had ownership of the lots. In this case, I agree. This is a way as opposed to a lot. But what I am saying is that the individuals who are using the way are claiming that they have certain rights to use that, whether it's what we call prescriptive rights or they have easements or whatever it may be. So the concept, again, is very much the same, namely that they're saying we have rights in this land that allows us to cross it. In the other cases, they're saying we have rights in that land that allows us to cross it, namely we own it. In this case, they would be saying we have rights in this land, namely we have either an easement by prescription or whatever it may be. So I agree, and I think I said, and I conceded, that yes, these cases are talking about lots as opposed to a way. But again, I say the concept is the same.
Ms. Mayhew?
Nothing.
Should we open it up to the public
I
comments?
have
or-
a question, Mr. Ryer.
Go ahead.
I see on this map that this property was previously owned by the current owners of the sand pit or relatives of theirs before these lots were sold to your clients?
That's correct.
I'd like to know what representation was made to your clients at the time they bought their residential lots from the operators of the sand pit about the use of the road.
Yeah, I think when they purchased it from these individuals, there was no heavy use. This use of this pit has intensified since they constructed their homes there.
Do you have a time on that?
I can
Timeline?
confer with my clients and get that for you.
Okay.
But I'm not sure that there were representations made, we're never going to use this for anything. It just wasn't being used for that. And then all of a sudden, within the last couple of years, and it intensified in use, and there were all these trucks going back and forth. And
Was there any use of the sand pit at the time your clients purchased their property?
I don't know. I can find out for you from whether they know or not.
Okay,
I
thank
could-
you.
Follow up.
If you want to give me a moment, I can ask them.
I would just, if this case is going to come back to the board, if you would be able to provide an affidavit from your clients stating exactly what they knew of the use of the property and when.
All right. And when you say use of the property, you mean use of the drive or use of the pit?
Both.
Or both? Okay.
Yeah.
All right.
Okay, anything further?
No, nothing further.
Okay, I'm going to open it up to the public. If anybody would like to speak in, I guess, let's see, in favor of their position, which is somewhat confusing. What they're saying is they want the building inspector to shut down the Deleuze's use but I don't want to get into whether the pit's good, the pit's not good, that's the next case. So let's just talk about the road. That's what's at issue with this case. Yes, ma'am.
So, I live at 1 Jay's.
Identify yourself and your address.
Andrea Monderer. I live at 1 Jay-Z Drive. We bought, I believe, in 2007, and we were the first house built. Yes, there was some activity of equipment going back and forth, but I can guarantee you there's been increased activity. I can't speak on behalf of the Rigos, but I can tell you there's been destruction and wear and tear of the road. I can tell you I have personally been fearful of being run off the road when I've been out there as a person, as well as in my car. There's been destruction of my grass. There has also been, my husband often will put up little sticks for our property line. They're often pushed over. We bought this home to get away from, we have another home, to come and relax. I feel constantly anxious when I'm in the house. The trucks go by and my house shakes, I get dust. I never open my windows because there's dust all over the place. It hasn't been a relaxing experience. And my property values have not increased, and I don't think they're going to increase. So it's wear and tear of the road, and it ruins my property values. I can't sell my house right now because of this business being operated here. So that's what I have to say.
Okay, thank you. Anyone else like to speak? Well, I guess it was in support of the petition. Anybody want to speak in opposition to the petition? Attorney Shilley, if you could come and
Thank you,
identify
Mr.
yourself
Chairman.
for the record, please.
I'm Attorney Frank Shealy from Chatham, and I represent the Deleuze family, the owners and operators of the pit, and also the users of what's come to be called Jay-Z Drive. And I think maybe a little history is instructive here because there's a lot of confusion. Today I had a chance to look at the 1910 Barnstable County Atlas, and to my absolute surprise, I find that what we call Jay-Z Drive now was actually a big road in 1910 and depicted on the county atlas. More importantly, it's important to understand that the Deleuze family owned the whole block of land from Queen Anne Road to the end of the Rago property. There was a dirt road that went right in over that area. When the subdivision was established that resulted in the Ragos lots, the town required that a name be designated for the quote-unquote road. They designated it as Jay-Z Drive. That was never its name historically at all. And Jay-Z Drive only goes to the end of the Rago property. Beyond that, there has existed for many years, and we think back as far as 1888, a dirt road that not only serviced the sand pit, but that went all the way across to Spruce Road, south of the Mid-Cape Highway, and probably crossed the Mid-Cape Highway before, when they extended it in the 1950s. It also, in our opinion, is a dirt road that went across Queen Anne Road over through the Cranberry Valley Golf Course, which no longer exists because the Cranberry Golf Course wiped out that whole road. So the trail of the dirt road, which we call an ancient way, has existed clearly since 1910 and probably since at least 1888 we've been able to find out so far. Now, it never had a real name. People called it by different names because it was a dirt road. In the old days, that was quite common. And if it is, in fact, established as an ancient way, I believe, contrary to what Mr. Sabat suggested, that is, in fact, a public way, because that's what they had in the old days before we had the statutes on how you establish public ways. Now, Jay-Z Drive, to the point of the end of the Rago lot, is, in fact, a private way. The town never accepted it. The people on it are responsible for its upkeep and its maintenance if there's issues therewith. The town won't do anything with it unless they seek to adopt a betterment assessment. But the suggestion that Jay-Z Drive is the critical term is wrong, because Jay-Z Drive just overlays a dirt trail or dirt road that's existed for many, many years, well before the subdivision. More importantly, when we look at the 1973 Board of Appeals special permit request by John Z. DeLuz Sr., the father of Cliff, John Z., and Margaret Wiegand, you will find that he indicated, and that will come in at some point here tonight, that not only was he asking for a special permit to mine sand and gravel, but he also asked that they continue the pre-existing use of the so-called dirt road. And that's clearly depicted on his application on the back side. I believe that when Mr. Sabat looked at the special permit that existed in 1973, and before Mr. Chesley responded to his request for enforcement, that he may have been unaware of the diagram that was on the very back of the application. That's part of the exhibit that came up the last time. In 1973, the Board of Appeals extended the continuation of that use out to Queen Anne Road to service the sand pit. So there's no question that there is legal authority and probably precedent for that old road being used. Now, how was it used? It was used clearly in conjunction with the sand pit. And that's what Mr. DeLuz, the elder Mr. DeLuz, requested of the Board of Appeals, because in 1973, in a totally residential zone, the bylaw provided that activity by virtue of a special permit. It wasn't an of right activity. It required a special permit, which issued unanimously in '73. Now, Mr. DeLuz did not need permission to get to the cranberry bog that he owned up in that area too, because the Harwich zoning bylaw provides that in cranberry bogs you can have a sand pit, which is part and parcel of growing cranberries. So he didn't apply for the removal of sand and gravel to do his cranberry bog. He applied it for an entirely new business. And that's why that section of the bylaw becomes extremely relevant. So to suggest that JZ Drive is somehow the private property of the Rigo brothers may not be factually accurate. More importantly, and I think somebody brought this up, these trucks have been going over this area well before the Rigos bought the property. Before they owned it, there were two other families, the Power family and the Donovan family, that bought those lots. Those trucks have been running back and forth since probably 1971 and maybe even before, because Mr. DeLuz, the gentleman who owned the cranberry bog, we have a deed in 1941. So we don't know how long that road has been used in conjunction with some kind of an agricultural or business-related use. Now, the suggestion that the activity on that dirt road has picked up, I don't know. I don't have any personal knowledge of that. I do know that there were other companies that were in there that were buying the sand and hauling it out themselves. There's no question about that. So the lawsuit in the Superior Court, in which I'm plaintiff's counsel, basically involves other people who claim rights over the so-called dirt road, which means they also have rights over, quote-unquote, JZ Drive, because that road was just overlaid on the old dirt road. So they didn't lose any rights by virtue of somebody putting some pavement on it or making it a private way that was an improved private way. They got the benefit of an enhanced road, in essence, is what's happened. So those people have nothing to do with this zoning-related issue. Their issue is an access issue. I just wanted to clear up the history of this quote-unquote dirt road that goes through this property that everybody wants to just limit to JZ Drive. Thank you.
Thank you. Anyone else in the public like to speak on this case? Attorney Sabat, anything further?
Yes, if I could respond briefly to two things. One is that I looked at the deed, I had an opportunity to look at the deed into, at least into Joseph Rigo and his wife. That is a deed from 2010. And with respect to the question of who owns the fee, the deed recites, it conveys into Mr. and Mrs. Rigo, and it provides, together with a non-exclusive right to use JZ Drive, as shown on said plan, for all purposes for which ways are customarily used in the town of Harwich, in common with the grantor, who in this case is a Brendan Donovan, whom I believe would have purchased from the DeLuzes. That's what I'm suspecting. And then reserving unto the grantors the fee in JZ Drive. And the grantors in this particular deed is Mr. Donovan. I think that's probably language that carried over from the first deed that went out from the DeLuzes. So even though this may have been shown on previous plans, JZ Drive itself is constituted has to be a private way because the fee is reserved into the names of the grantors. And my clients have easement rights over it. With respect to the 1973 decision and the roadway that Mr. Shealy says is clearly shown, it's, if anything, that sketch is unclear. You can't identify exactly what road this request in 1973 is referring to. So it's unclear that it's referring to what we now call JZ Drive and the roadway that runs north of it. I don't get that, or I can't get that specifically from this particular sketch. What's also interesting in 1973 is that in that decision, one of the things that Mr. Deleuze was asking for was permission to use the existing road leading to and from the existing sand pit, and it says in accordance with wetland regulation, which I'm unable to find. I was unable to find anything on that from back in 1973. But here's what the decision said. This is what your predecessors said, the Zoning Board of Appeals, in their decision. In a separate action, the board voted unanimously to grant the continuation of the non-conforming use with the qualification that the petitioner be subject to certain conditions to be laid down by the town engineer in respect to the road in question. So part of his request for relief in 1973 was permission to use this road as an access way into the sand pit, which is coming back to the same issue that I'm raising here tonight in my petition. So to your point, Mr. Burke, where you talk about whether there's anything in the bylaw, now, I agree. There's nothing specific that I could point to, but the concept's the same. Back in 1973, somehow or other, he felt the need to be requesting permission to use some road that was an access road. And by the way, I went to the engineer's office to see if they had anything at all on this, and they had nothing. There was no record available on that particular road. And then the final point I'd like to make is that with respect to the question of what use, my clients would submit that they were not aware of the sand pit use when they purchased their property. They didn't know that there was a sand pit that was being used in the back. And as the other abutter expressed to you, and as I've expressed to you, that this use is really intensified, and that's what brought this to a head over the last few years. Thank you.
Anything further from the board at this time? All right, I think we'll,
Question.
yes.
I understand that you are in Superior Court over the matter of the ancient way, but I'd be interested to hear you speak more about the issue of the ancient way, how JZ Drive overlaps this old road or ancient way, however you wish to describe it.
Yeah.
That's the first I'd like to hear about. And secondly, you made a point of saying that the petitioner sought a special use permit, and then he sought continuation for non-conforming use. As attorneys, we throw lots and lots of counts in our complaints, spaghetti against the wall. We hope that something sticks. So I do not find it unusual at all that they would cover all their bases by seeking these different avenues. And the fact that the town granted all of the relief which they asked for, not only granted it, but by unanimous vote, and went so far as to say that the use over this road is certainly a desirable one. You don't see that in every decision. So that's the second subject I'd like to hear you speak about.
Well, as to the first one, I don't necessarily, I'm not willing to concede yet, and that's what's going to be decided in Superior Court, is whether this is an ancient way or not. You're obviously not the land court, so we can't get into the subject tonight of what does it mean to be an ancient way, but my position is that merely because you have an ancient way doesn't mean that it's necessarily a public way, that the public has unlimited rights of access in it. but again, that's for another forum and another day. Jay-Z Drive does cover part of, it expands beyond, if I look at this plan, it expands beyond what is the original, what Mr. Shealy contends was shown on some 1910 atlas. You see you see the dark lines of what outlines Jay-Z Way, and then you can see the narrower lines that are coming up the center of that. Now, I don't know if that conforms to what he sees on the atlas or not, but it seems to be showing some sort of a pre-existing way. And you can see up at the top that, that the planning board permitted, because it's shown on the plan, existing portion of road to be abandoned. So part of it was abandoned, and then there was a new section that is illustrated here, something brand new that is certainly not ancient. So, so to answer your question, is that Jay-Z Drive itself is broader, at least I think it's broader based on this plan, than what any, assuming there is an ancient way, than what any ancient way may be. And again, I don't have the benefit of the 1910 atlas, and we'd really have to scale it off and know, is that center line the same as what we see in the 1910 atlas? Those are all questions for the Superior Court, but that would be my answer to your question on that point. On your second point, what I was trying to say is I find it interesting that John DeLuz in 1973, as a part of his request for relief, was asking for permission to use the existing road leading to and from the existing sand pit, and he says in accordance with wetland regulation, whatever that was, and that's not addressed in the decision. So there is a principle of zoning law that says if you ask for relief, you are deemed to have been required to have such relief. And so obviously there was something in 1973 that he felt it necessitated that he needed not only permission to use the pit, but permission to use the access way as well. That's my point, which I think is germane to my argument tonight.
Okay, I'd like to stop at this point and take the next case, and then we will revisit this case. Mr. Clerk, could you call the
Okay,
next
so
case?
we'll continue this case generally then until later in the evening. Now we're gonna call case 2017. Lewis Jr. and Margaret Wygarn, through their agent, attorney Frank Shealy, are appealing a cease and desist order issued by the building commissioner on May 23rd, 2017, to halt any and all commercial activity at a sand pit located off Jay-Z Drive until application, appropriate zoning relief, and an operations permit from the Harwich Planning Board. Applicants claim they have a pre-existing non-conforming status under MGL Chapter 40A, Section 6, and Section 325-26 of the Harwich zoning bylaws. Property is located off Jay-Z Drive, assessors map miscellaneous parcel number 4054001 in the RR zoning district.
Good evening, Mr. Chairman.
Just identify yourself again for the record with your issue.
Attorney Frank Shealy from Chatham, Massachusetts, representing Clifford DeLuz, John Z. DeLuz Jr., and their sister Margaret Wiegand, formerly DeLuz.
Okay, just before you go on, just to confirm once more, the voting members are going to be Mr. Donahue, Mr. Burke, me, Ms. Muller, and Mr. Hilliard. So you'll have 5. So we're going to make believe the first hearing didn't occur. You're going to start from scratch, so it'll be in effect a new hearing, just for
Fine.
the record.
Thank you, Mr. Chairman.
Thank you.
We are appealing the cease and desist order entered by your building inspector, Mr. Chesley, in response to a request for enforcement of the zoning bylaw by the Rago brothers, represented by Mr. Abbott. And I'm happy to hear that the issue is now kind of scoped down to the issue of Jay-Z Drive in terms of their appeal, but our appeal goes even further. In 1973, the senior John Z. DeLuz filed with the Harwich Zoning Board of Appeals for a special permit under the then existing bylaw for permission, special permit to remove move and take sand and gravel from his existing pit, as was described on the listed on the back of his application.
Wait a minute. We have the microphones on the table now, so every time we drag the plans over, we're getting all that static. So just be careful. Thanks. 'cause of
Okay, now, to the
recording.
extent this is a
I'm
new
sorry, go
hearing,
ahead.
I probably should reintroduce some exhibits for the board members, so I don't assume
Yes,
people
please.
have. I have copies of the Board of Appeals decision, the sketch that was attached to the application, and a copy of the written decision dated October 9th, 1973, and I think I want five. I can distribute copies to each of your members with your permission, Mr. Chairman.
I have one on it. It's only Mr. Hillier. We all should have the package.
I have.
I think we've all got it
I
then.
need one. I need one.
Okay, Mr. Burke needs one.
Okay, fine, then I'll,
Wait, Mr. Burke needs one.
oh, thank you. Now, keeping in mind that the totality of this property is all in a residential zone, there is no commercial zone, industrial zone, or anything else involved in any of the land that's before the board tonight. In 1973, if you wanted to have a sand pit in the town of Harwich, and you were in a residential zone, you were allowed to apply to the Board of Appeals for a special permit. And that's specifically set forth in the 73 bylaw on page numbered 16 under use regulations, which states, removal of sand, gravel, quarry, or other raw material in an RL or RM zone is by special permit. So Mr. DeLue applied under that section, and attached to his application, he enclosed a quote-unquote sketch indicating Queen Anne Road, Old Nate Walker Road, and some other dirt roads that went up to his quote-unquote existing pit area, which he highlighted, which he depicted on the sketch, and it was in relationship somewhat to a bog that was also apparently owned by the DeLuce family, being a so-called cranberry bog. Now, under the bylaw, he did not need any permission to take sand for his cranberry bog, and that appears in your bylaw, 73 bylaw, on page number 9, under agriculture, paragraph 3, cranberry bogs, including accessory buildings and sand pits, they are permitted. So there was never a need to a special permit in any way associated with this cranberry bog. He further applied to continue a pre-existing use of the so-called dirt road. Now, the dirt road, at least in Mr. Burke's copy, I have highlighted in red. And that dirt road exists today and has existed for many, many years. I don't know if on the other packets I highlighted it. If not, I'd be happy to share the one that Mr. Burke has to show the dirt road that leads
That's the
up to the pit.
road on the back of the application. Yes,
Yes, Mr. Chairman.
thank you.
It leads from Queen Anne Road up to quote-unquote existing pit area. That's the dirt road we're talking about.
Okay, there's two roads on there. One says something Sat Road, I can't make it. Yours is
One
to
just says road.
the left of it, just
and
says
then-
RD.
No, it's not the, I think that's probably Somerset Road. There is a Somerset Road along.
Somerset Road, okay.
I think it was misspelled.
And the one you're referring to
Is
is the
to
one
its
that just
immediate
says
left.
RD.
Yes.
Okay, thank you.
Exactly right. And that leads right directly up to the existing pit area. Now, in his application, he indicated that not only was the special permit, but he was looking to continue a non-conforming use to permit the existing road leading to and from the existing sand pit. And both of those requests were granted unanimously by the Zoning Board of Appeals. Now, what's happened is that since then, obviously, because it's a quarrying operation, the pit has expanded from the original pit that existed in 1973. 44 years have elapsed since the pit, this special permit was issued. And there's been a major excavation up there by the DeLuce family and their employees of the sand and the rocks. The only thing that they were doing up there was excavating the sand, sifting out the rocks, selling the rocks separately, and then selling the sand and the fill separately. Initially, there was no activity by Mr. Barrows, Brian Barrows of Barrows Construction, nor by Jay Brown. And we have made arrangements with them to clear out whatever they were doing up there. And in all fairness, Mr. Chesley's been very helpful in allowing them to remove all that stuff that they had up there that is outside of the permit that issued in 1973, and we concede that. Mr. Barrows has used a lot of the material to make a new road up off 39, And I was up there the other day, and it looks like Jay Brown has removed a lot of the screened loam that he had been using in his landscaping business. So those operations will no longer exist once these gentlemen have been able to remove all that inventory from the site. There will be continued mining of the sand and whatever comes out of the sand up there. Now, in 1978, Cliff Deleuze, who ran Deleuze Construction, excavating under different names over the years, in 1971 began working that pit because he opened his own company with his dad. And Cliff has been the primary excavator of that sand pit. When his father told him years ago that he owned all this land up in North Harwich, Cliff didn't know what he meant. He knew where the bog was and he knew where a small pit was, but he wanted some certainty so he could be guided. And in 1978, he requested Schofield Brothers Engineering in Orleans to go out and do an instrument survey based on deeds that the family had assembled. And that resulted in a plan that Mr. Deleuze had, and I turned it over to the board back in July 26th, that did not get recorded. It was a guide for Mr. Deleuze as to where the father's land was, based on the deeds that the Schofield Engineering firm had assembled in somewhat of a puzzle fashion and depicted on the plan that I believe all the board members, possibly Mr. Hilliard does not have one, but I have one. Do you need one, sir? I can give you one. Oh, okay. So that depicted the quote-unquote area of the pit back then, and more importantly, it depicted the area of the cleared land. Because as part of the pit, you clear all the top off to get to the soil, and that's what was going on. So in 78, they showed both the existing pit area, as they understood it, and the cleared area. Now, there is a last hearing I was at on July 26th, you requested that we have a new plan done to show what's out there right now. And we retained John O'Reilly and Brewster to do so. And yesterday I brought those plans to Ms. Delaney to include in your packet. And hopefully you all have those. That was consistent with the request made by the board to show what's on the ground up there now. And you'll immediately see that consistent with a sand pit operation, the pit is much larger now, 44 years later, than it was in 1978. And more importantly, you'll see also that more of the land has been cleared than was depicted on the 1978 plan. And this is all consistent with the special permit that was obtained, because the permission being sought was to run basically a sand pit operation, not a cranberry operation or anything else, but a sand pit operation. Now, this property is a half a mile in from Queen Anne Road. Until I got involved in this case, I didn't know it existed. I've been up there multiple times now to see what's been going on. I've had it photographed aerially to get a sense of the expansion of the pit. And there's still an awful lot of product on the property. The pit is where it is because if anybody's been up there, you'll see that there's big hills and mounds there. They're not just scraping off level dirt. There's big mounds up there that kind of beg to be taken for fill and for the sand. Now, we don't know how much fill is still there, but we're talking hundreds of thousands of yards that still remain on that site of the property that the Deleuze's own, that is covered by the special permit. More importantly, the access to the road that Mr. Sabat has somewhat focused on not only has existed on the ground for many, many years before 1973, but it specifically was permitted to be continued, not initiated, but continued for the operation of the sand pit. So that the two issues that Mr. Chesley issued the cease and desist order on seem to have been complied with this explanation about the history of what's been going on the behalf of the Deleuze family up in this pit area. They own the area, they've been mining it pursuant to the special permit, and have been using the road historically from probably 1941 when their father, I found one deed back in 1941 that was probably in conjunction with the cranberry bog and a small pit. Now, by a small pit, I probably mean something with wheelbarrows and small pickup trucks, nothing with all the machinery that these fellows now use in the enterprise. For the Regos to suggest they were unaware of the activity in this area challenges credibility, because all you have to do is drive in over the road and keep going one of the one of the brothers' wife has horses, and when I've been up there, I see horses riding up all on these dirt roads up there. So to suggest they didn't know what was going on up there, other there was no sand pit, in my opinion, challenges the credibility of what they actually observed and knew was going on. But that's not the issue, because whether they knew it was going on or not, certain rights had vested for this sand pit operation. Now, what I'm hearing is that the use is intensified. Well, that doesn't have anything to do with the zoning permission. The zoning permit was not limited to 3 truckloads a day or any kinds of equipment. What does go on up there is, in order to shake the rocks out of the dirt, you need a sifter. It's not a machine that you throw a tree into and it chips it all up and you blend it in. It's strictly a sifting machine. So to suggest that we're mining or recycling wood product up there is not accurate. What did happen is, when the land was initially cleared, you will see up there a pile of wood chips. They chipped up a lot of the branches and stuff of the trees that were cleared off the surface, and some of them are just like a big corral on the upper rims of the property, where they were just kind of pushed aside. So I'm suggesting that the cease and desist order should be lifted, because everything that's going on up there is illegal and approved by the Town of Harwich Zoning Board of Appeals, and there's been no one else has claimed any title to the property. No one's made any claim of any other use of the property but for the Rigo brothers. So I want to commend Mr. Chesley for working with us and trying to get some of the stuff that doesn't belong there off the site, but the underlying core cause of the sand pit, in our opinion, continues to exist with the rights to get out there onto Queen Anne Road. If you have any questions, I'd be happy to entertain them. I did find in my packet, and I'll just interject this, there was a suggestion about the dirt road. Before Jay-Z Drive existed, in 1973, there was a plan done by Clifford Deleuze showing the parcel of property they owned from Queen Anne Road into where the Regal lots end. And that plan shows a dirt road. Now, when they subdivided it, the Jay-Z Drive goes on top of the old dirt road. So the dirt road did exist at least in 1973, and we suggest much earlier than that, probably at least 1910, maybe 1888. So this is not a new road. And everybody has rights of access over it that has interior land, and that's what the Superior Court case is about. That has nothing to do really with its zoning matter.
Okay, I'm going to kick it off. The problem I have with your position is, under the 1973 bylaw, under which the permit was granted, Section 11A12 says, a special permit, if issued, shall be issued for an initial 3-year period. A renewal permit shall be necessary after a 3-year period from the board. That's still part of the present bylaw, now known as Article 15, Section 32589, excavation and removal of sand, gravel, quarry, or other earth materials. And if you look down, L says a special permit, if issued, shall be issued for the initial 3-year period. A renewal period shall be necessary after a 3-year period from the board. As far as we know, there's been no renewal period, no renewal certificate issued after the expiration. Your special permit expired. The continued operation was an unlawful operation, and if you look at Section 32596 of the Six Ponds Special District, it only exempts from its requirements lawfully existing uses. So under my reading of the bylaw, that the sand and gravel operation has been illegal since 3 years after the issuance of the permit, and what must be obtained is a special permit from the planning board under 32594 and an operating permit under Section 325-102. So I don't think your position is valid relying on that special permit. I think it's expired.
Could I draw your attention to the rest of that section you referred to? I refer you to the 1973 zoning bylaw in that section that's called Section 11, Special Conditions. Number 14, all sand and gravel pits presently operated as such are exempt from the requirements of obtaining a permit, but must conform to all other conditions of this section.
But you got a permit, so obviously your client's predecessor in title recognized that he needed the permit.
Well, the bylaw is very confusing in terms of, this fellow claimed that he had an existing pit in his application, sir. I mean, I have to be guided by what I can read, because I wasn't around.
Okay, I
So
don't,
he said he
I
had an
think your
existing.
I think your position is without merit.
Well,
So,
that may
I mean,
be.
that's my view. I will know,
But let me make one other comment, sir. Somebody has alluded to the Six Ponds District. Six Ponds District was not enacted as a zoning amendment or bylaw until the year 2001. So we're not covered by the Six Ponds District under our special permit.
you are covered if you had an unlawful use. And if you're operating without the renewal permit, in my opinion, that's an unlawful use. So you are covered by the Six Ponds Special District. It only exempts lawfully existing uses. Mr. Torek, any questions? No questions. Mr. Hilliard?
Thank you, Mr. Shuey. How would you characterize the intensity of the use at this site from 1973 to today?
Oh, it's been extensive. I mean,
Extensive.
I think the plan that I left with Mr. Lane
I saw that.
yesterday will depict that went over, and the red marks there are the 1978 plan, so the new
Yeah, I saw that.
survey overlays the 78 plan
Okay.
as per the request of
And
the board.
it's been extensive not only in removal of gravel, but trucks in and out, or whatever the vehicles are that are removing it.
Well, I think the trucking is on an as-needed basis. If the
Yep.
economy is strong, there's more need for fill and,
Okay.
and beach sand and road salt for the towns buy from this pit.
So notwithstanding the prior conversation, if there's been an increase, a substantial increase in the use of a pre-existing non-conforming use, would you agree that that at least would require a special permit or an amendment to the original permit? Because my understanding is you had a special permit to remove gravel, or remove sand and gravel.
Yes, sir.
And during that period of time, there's been a substantial increase in that. So now, because of a complaint that's come before us, we're looking at it from the point of view of, can you continue? As you, I believe you, what this comes up to, based on what the building inspector has said to you, is you want to continue what you're doing. And one way of continuing that, I would imagine, is to get an increase, get a amendment either to your original special permit, or ask for a special permit to extend a pre-existing non-conforming use. Problem is that it is not a pre-existing non-conforming use, because it was ordered by special permit. And special permits are not a lawful pre-existing non-conforming use, at least not according to my knowledge of reading the case law. So, having said that, what are you asking for the board to do that puts your clients back in business?
To lift the cease and desist order.
Okay. And if the cease and desist order is lifted, do you have any issue then with the substantial increase in the activity that was initially granted back in 1973?
None whatsoever. And the reason is
Okay.
because, in our opinion, that is an ancient way which would make it a public road, and it's not an issue of overburdening an easement, because no one has easements in the road. There is a concept of overburdening an easement, but that's not the situation here if in fact it's a public way or an ancient way.
I don't have an issue with the road. I think that's a personal issue between who owns it and who claims to own it, and I don't think that's something that this board would deal with anyway. I mean, the issue is use, and that's what I believe, that one of the major issues, that why the building inspector sent you the notice. Okay, I have no further questions.
Ms. Muller?
Yes, I'm a little confused about who operates the land versus who owns the land. Who owns this property?
Well, right now, as a result of the death of their father, the three DeLuzes, John Z., Clifford, and his sister, own a third interest in the property as a result of his...
They are the owners of the land?
They are the owners of this
Okay,
property, yes.
and who's been paying the taxes on the land since the death of their father?
My understanding is the town has not assessed it,
Okay,
in spite of them knowing that at least Mr. DeLuz owned the Cranberry Bog on their 1963 assessing map. I don't know why they didn't assess it.
Okay, and is it your contention that all activity that does not, that goes beyond removing sand and fill has been stopped?
Well, we're in the process of cleaning it up. You've got, Mr. Chesley's been working with Mr. Barrows and Mr. Brown to get out of there the material that probably shouldn't be there.
Okay, and I believe you said that the sand pit has expanded considerably in 44 years.
Yes.
How do you reconcile the concept of considerable expansion in 44 years with a special permit issued for the existing pit?
No, that's not what this is some of the confusion that I think exists. The special permit was to allow him to mine sand and gravel in that area. It was not confined to a particular area because that would be silly. He already had a pit area, and when you excavate up in that area, you make the pit larger. That's the nature of almost a mining operation.
And yet the permit says from an existing pit.
Right, and you expand that. I mean, there'd be no need to apply from an existing permit if it had already been excavated. I mean, if he had excavated the area that is depicted on the 1978 plan, he would not need a special permit, because he'd already done it.
So your contention is whether something is 1 square acre, if it's 1 square acre at the time the permit is issued, and the activity extends to 10 square acres, it's still the existing sand pit?
It is the sand pit, because the sand pit is the area to be mined.
Okay, and I see in the decision from October 1973 that one of the conditions on which it was based is that there is no immediate detriment or danger to the neighborhood. We seem to be hearing testimony this evening that there is in fact now, in the perception of some, detriment and danger to the neighborhood.
That had nothing to do with the 73 application. You gotta put this in the time frame in which it issued.
So you can be issued a special permit with a condition or on a basis that it's no detriment to the neighborhood, and then detriment and danger to the neighborhood can be brought into existence later, and that's cool.
No, because the lady that spoke in favor of the earlier petition doesn't even live near the sand pit. She lives out on the edge of Queen Anne Road.
And would you say that there is
And the pit
still,
is a half a mile in from there.
would you say there is still no immediate detriment or danger to the neighborhood?
Absolutely.
Okay, thank you.
If you drive up there, it's all woods up through there. Your Vasca property is gonna be bought by the Harwich Conservation Commission, so that'll remain in its woodland condition. And up there are cranberry bogs. I don't know if you had an opportunity to drive there, but
I have driven up as
Yeah.
far as one can go.
did you get into the pit?
No, because it was blocked. You couldn't go in there.
Wow, I've been there 5 times, never been blocked.
But I think the question of what is the neighborhood? Is the neighborhood only the existing sand pit, or is the neighborhood extended to Queen Anne Road?
Well, I don't know how anybody can object to the sand pit if they don't even live within hundreds of feet of it. The only objection I heard was the use of the road, not the use of the sand pit.
Which seems to bring some detriment and danger to the neighborhood
Well, one person said she
pursuant to
can't
the
sell.
operation of the sand pit.
One person says she can't sell a house because of the sand pit. She knew about the sand pit when she bought the house.
No further questions?
Mr. Chesley, any comments?
This outline on this plan that you submitted today?
That's the new one from John Riley, yes.
Okay, and what is it, what is that outline, the dark outline? Is that the property line, or is that,
Excuse me.
I'm a little confused about the note.
Okay, well, the property line. The dark line is the property line as established by Schofield in 1978. This dark line that goes here, and here, here, that's the property line from 78.
Okay.
Okay, now in 78, there was also an infringement on the property line, if you'll notice from the 78 plans. The infringement is even more extensive at this point, if O'Reilly's right. They've gone up onto, I don't know whose property this is.
Right. So it's migrated off of the original?
Yeah, what appears.
Okay.
Well, an objection by anybody.
Okay. But this outline is the outline that of the property that the Deluzes own? Is this the traverse of their lot that they own here?
The dark lines would be the lines that Schofield said they owned as of 1978 by deeds that they had
Okay.
of record.
Okay,
The rest of them, it's probably an address possession claim at this point.
okay, thank you.
Okay, I guess I've already stated my comment. I think the permit expired in '76. They've been operating illegally. I think they're subject to the current bylaws, including the 6 Pond District requirements. Just one, you've been cleaning the site. Now, I just want to make sure they have not been removing sand in violation of the cease and desist order.
The only thing that's been removed there is by Mr. Barrows and by Mr. Brown. My people have taken nothing out of there.
Okay, thank you. Mr. Burke?
Just to make sure we focus on what we're here for tonight, it's an appeal of an cease and desist order.
It is, sir.
All right. So it's a little narrower than what we've gotten a little far afield, and I just want to ask the commissioner a couple of questions. You issued the cease and desist order to cease the use of any commercial activity in the sand pit. Did you issue that on the basis that you were not convinced this was a pre-existing non-conforming use, or did you issue that cease and desist on the basis that the permit had expired?
Well, we felt that the permit had expired, and that was the basis that we proceeded on.
So that was the legal basis on which you
Initially,
that,
yes,
all right.
yes.
Were you asked to make any determination that this was a pre-existing non-conforming use?
No, I don't think we were. But we just,
It was solely on the basis?
Yes,
You received a
right.
complaint, you viewed the permit, and you viewed that it had expired.
yes. Yes.
Issued the cease and desist, and here we are.
Well, that's the first thing that I've heard, or my clients have heard about the position. Mr. Chesley just verbalized that it was predicated on the fact that the permit had expired. I actually met with your town council, the town administrator, Mr. Chesley, and a woman from the Conservation Commission. In response to Mr. Chesley's suggestion, we get together. The town council, I forget her name, a woman, indicated that the special permit was still in effect. They understood that. So to now hear that the special permit has expired and that's the predicate for the cease and desist order is, to put it mildly, a surprise.
Well, I think.
It's not in the cease and desist letter. Mr. Chesley's never told me that, so,
Well, I think it developed as we get into the case. So,
Is it your position then that this is a pre-existing non-conforming use, irregardless of the permit?
yes, based on what I'm finding out,
Okay.
probably since 1941, before your zoning bylaw, which was 1951.
Okay. And what do we have in front of us that proves that?
Well, the deed from Mr. John Z.'s father, in 1941, that talks about the pit. The rest of those deeds are all in the possession of the Schofield brothers, and
Well, how would deeds establish a use?
that established what was going on the property. If it referred to a pit, or it referred to a bog, or referred to a home on it, or a structure, some of the deeds are very instructive.
But it could have referred to the pit used for the cranberry bog. And that's why in '73, when he was gonna repurpose the pit for landscaping, he went for the permit.
No, because he didn't need that permission, sir. Under the
He
design.
didn't need it for the cranberry bog.
We follow your argument,
Right,
that's the correct, all right? And that you wouldn't need it, so that's not a pre-existing non-conforming use. It was an allowed use.
That allowed use, the cranberry bog
All
with
right,
the
but
pit.
when he decided that he was gonna take this material off-site for other purposes, we have no proof in front of us right now that use was a pre-existing non-conforming use.
Well, if you read the application, I believe he alludes to the fact that he was in the landscaping business, and he'd been doing this before, but now he
I
just,
understand the application, but
right.
your basis as a pre-existing non-conforming use.
right.
We have no proof in front of us that the use to take this product off for a use other than a cranberry bog was pre-existing non-conforming. I don't see a thing here.
So what you're looking for is some proof that there was a pre-existing.
If your basis of appeal here in overturning this is that it's a pre-existing non-conforming use, we have no evidence to that effect.
I think my appeal is that there was a special permit in 1973. That was the response to Mr. Chesley's cease and desist.
We're talking now about pre-existing non-conforming use. There is no evidence.
Well, if you take,
You go back to the permit, it's expired.
okay,
We're
what we
gonna
don't know.
Get into a box one way or the other here.
What we don't know, Mr. Burke, is when Mr. Deleuze in 1973 said, asking permit to remove or take sand from my pre-existing pit, how long had it been pre-existing? And maybe that's your question. How
Yeah,
long was it?
there's no proof.
Well, the
We would certainly need some empirical evidence of some type here to overturn the building inspector, not just a casual reference to, well, it must have been.
Well, all the people,
Certainly, the burden would be on the property owner to establish a pre-existing non-conforming use. Obviously, the building inspector the commissioner was not satisfied, or he hasn't received any evidence. We haven't certainly heard any tonight that would convince me that the use, meaning the use for purposes other than the cranberry bog, was pre-existing non-conforming. Predates our zoning bylaw.
okay. I don't have any right now
Okay, thank you.
to present to you.
Mr. Donahue?
The cranberry bog, we agree, is grandfathered in, and the edge of the pit, 78. Is the area in which the permit now is no longer in effect. It was issued in 73, it was good for 3 years. So 76 would have been the time for the permit to be renewed. The property and the excavation of it had been increased by that time quite dramatically. I have to agree with Mr. Burke on this, that the permit, because of it not being renewed, and the expansiveness of the pit is where the problem lies.
Well, I can only say that the expansion of the pit is consistent with the sand pit operation. You go around to Robert Howe, you go to Bob Childs, you go to Cape Gravel, you go over to Freeman's Way to Chase and Merchant. That's what's going on in sand pits.
But there was a permit issued on this one.
Yes, no question about it, yeah.
So for a fact, we do not know that the operation of Robert Hour and Childs are operating under the same conditions.
Oh, no, I didn't mean to suggest that. I'm just suggesting that's the nature of a sand pit, is the removal of the fill.
Thank you.
Mr. Capoli?
Yes, Mr. Ryer asked you a question earlier about whether the permit was required to be renewed every 3 years, and you pointed us to a section that I didn't jot that down.
Okay, well, I'm referring to the 73 zoning bylaw, which I got from the town clerk recently, and I'm referring to section X1. You may not have the 73 bylaw with you.
Do not.
But paragraph number 14 says, after everything else that's in here, all sand and gravel pits presently operated as such are exempt from the requirement of obtaining a permit, but must conform to all other conditions of this section. And there's a bunch of different sections here about where the pits and everything should be. I mean, there's no question that was in the 73 bylaw.
That's, excuse me, could you read that language? It's all existing,
Yes,
which we have no proof of.
except Mr. Deleuze's representation in his application, he had an existing pit.
Well, but if that applied, he would not have been in filing for a special permit. He obviously recognized the need for a special permit because he filed for one. He didn't say, hey, I don't need one because section 14 says I'm exempt. So obviously, he recognized that section 14 did not apply to him. And he filed for a special permit. He was granted it. It had a 3-year life, had to be renewed. He didn't. The operation since then has been unlawful, and our building commissioner rightfully issued a cease and desist order. I don't, and Mr. Burke has correctly pointed out, there's been no evidence presented that was a pre-existing operation at the pit for anything other than cranberry bog use. And I believe that's why he felt the need to file for the permit in order to take it off-site for his landscape business. That's the way I look at it, so. Anything further, Mr. Capoli? I'm going to skip over Ms. Mayhew, then we'll come back to you.
Nothing.
Okay, Mr. Capoli.
Um,
Recognizing we still have
Yes,
a bunch of
not at
cases
this
behind
time.
us here.
No, not at this time.
Would anybody in the public like to speak to this case, either for or against? Yes, sir, come to the podium, please, and identify yourself.
My name is Ray Hebert, 5 Cranberry Hollow Way, Harwich. I would only like to address Mrs. Muller's point about the neighborhood. The neighborhood that seems to be being discussed is the neighborhood on Jay-Z Way. On Cranberry Hollow, when I bought my property 20 years ago, I couldn't see a sand pit. There was an ancient way. I used to walk my dogs. I used to see the horses walk by there. I used to see deer hunters and bird hunters walking back there. And I would follow the trail down. And when I took that trail down to the end of the trail, there was a stump dump, but there was no pit. Now the stump dump is gone, and I can see the sand pit from my kitchen window. I didn't see that 20 years ago. So you have a new neighborhood to consider as you move forward too, because now it's encroaching on us. Where does this thing stop? You know, does it stop at my property line? The noise coming from this shaker thing is incredible. The windows rattle, the pictures on the wall move. When it's operating, it's annoying. It's no longer the neighborhood it was 20 years ago. So just keep that in mind, that there's more than the neighborhood of Jay-Z Way.
Thank you, sir. Anyone else? Yes, attorneys, oh, somebody in the back? Okay.
I'm Dave Callahan. I spoke at the meeting in July. I'm on the Real Estate and Open Space Committee, and we've been looking at that property up there as owners unknown. I want to make a couple of points here. First of all, that 1973 permit, as we all know, contains a hand-drawn diagram of where this pit is located. I'm going to pass out something in a few moments that shows that, at best, that hand drawing might have been about 3 acres. Now, obviously, it certainly wasn't 9 acres, the whole lot. And I really have 2 issues with that permit. That the permit did not specify how much that pit could grow, and so you could I've heard the argument that it could grow to the full 9 acres that's in this plan. And the second item I've got a problem with is it's signed by someone who signed a statement, and it says on there, I am or are the owners of the property involved. And so far, we've seen no proof at all that, in fact, that property does belong to the DeLuzes. I'd like to pass out to the board, and I made copies to give to others as well. Of a number of aerial images.
You have one I might look at, sir? Oh, thank you.
Of the property, based upon, I started with Google Earth and found out that they didn't go back far enough. So if you look at this series of plans, it's about 11 pages of a number of images. The first few images were obtained from a company called Call East in Northampton, or North Adams, Massachusetts, who does aerial photography. And in '71, if you look, it's really hard to see, but there is actually you can see the cranberry bog at the north end of Eldridge Pond, or Briars Pond, or whatever you want to call it. But it's real tough to see the pit. So I blew that up a little bit on the second page, and you can see the extent of the pit in 1971. Now that's right across the culvert between the 2 bogs. The bog that is mentioned in the deed that everyone's referencing is that one at the north end of of Briar's Pond. If you go to page 3, which was the next image I could get, was 1975. So sometime between 1971 and the second page image and the third page image was when that special permit was provided. And I did make a note here that if you look on the far left side of that image, you can see a trail. That trail still exists, and it's right at the edge of the most recent clearing in the bog. The next page consists of an image from 1984, also obtained from Call East, and it's grown pretty far to the north, which we'll see in a second is actually encroached over into the Copeless property. On the next page, I'm now getting into color images because that's what I can get from Google, and I apologize for the top image. It does not, it's a little dark, and there's a blue line. Now, this is from June 2014. And that blue line, oops, that page? I guess I forgot, I didn't include the 2012 image. The blue line represents what I found from Google. It was the size of the pit in 2012. So the question was raised about, has the activity increased over the last few years? The blue line was the 2012, and you can see a little bit of growth coming down to the southwest. In 2015 was when I really became aware of the amount of activity that was going on in there. And that bottom image, it shows the blue line, and then there's a red line at the bottom, and that's the amount of excavation that has occurred since 2012. So the original, let's say 2012, it looked to me like the sand pit was about 7.98 acres, according to Google. And in 2012, they had added, by 2012, they added another acre. There's some 2016, not much change had occurred between 2015 and 16. The bottom image on that page, though, is kind of telling. The 1978 plan that they've been presented tonight is represented by that yellow line. And in fact, probably a third of that pit is on property that they don't own. I'm not saying that they own the right-hand side of the yellow line, but the stuff that's over on the left-hand side is not. What is in the light green there represents what is approximate from the 1973 plan. So from this, you can get a sense of how the whole system has grown. The last one is just from actually this last April. And the light green area represents the hand-drawn estimate, and the big green area is the area identified by the Schofield Brothers plan. Everything that's not colored green is outside of their property. So that's number one. The fact that Deleuze has signed this 1973 permit that he owned the property. It's been described that this deed, that I believe their lawyer has referenced, actually has 3 parcels, and I mentioned this the last time around. There are 3 parcels. One of them was the original Zachariah Deleuze homestead, I believe, it was called. Actually, I've got it here. I can go. It was the homestead of the late Zachariah Deleuze on the south by Queen Anne Road, on the east by the old Packet, west by the old Packet Road, which I believe is Oak Street. Lot number 2 is a cranberry bog near Leonard's, wherever that is, we're not sure, containing about 1/4 of an acre. The first lot doesn't specify a size, and lot 3 is another cranberry bog on Briar's Pond. I suspect this is the one at the north, consisting of 1 acre. The miscellaneous category that the assessor has assessed to Deleuze contains only 1 acre. And I believe that is only parcels 2 and 3. And the reason I do that is that Lot 1 was used in a plan in Book 50, or 571, page 60, which refers to the lot on that deed, which is Book 576, page 507. And on that plan, they refer to the lot as being Lot 1. So the 3 lots that the Deleuze is currently paying taxes on is a house lot on the corner of Oak Street. It was actually now split into 2, Oak Street and Queen Anne, a cranberry bog of 1/4 acre, and another cranberry bog of 3/4 acres. And so there's no representation, and I was hoping that they would be coming in with something so that they would start paying taxes on this stuff, if they do own it. That the question was raised that it hasn't been assessed. The assessor cannot tax something that they don't know who owns it. And I guess I'm pretty upset as a taxpayer in this town that there are a number of parcels, and I'm discovering in this owner's unknown research, that are like this, that are used or claimed to be owned by people, old timers here on the Cape, that passed down through the family in a variety of ways, but nobody's paying taxes on them, and some of them are very large. Thank you.
Thank you, sir. Attorney Sabat.
I want to go first to the issue that you raised with respect to the 1973 requirement that exists today, that the permit needed to be renewed every 3 years in order to remain in effect. And the fact of the matter is, there's no evidence, either on record in the registry or here in the town hall, that there was ever a renewal of that original permit from 1973. That permit has expired. And to the point that it expired in 1976. To the extent that, that there may have been an existing pit, to that point, in the application itself, if you read the application was filed in August of 1973, and in his application to the board, Mr. Deleuze stated that he was asking for a permit to remove or take sand and fill from my existing pit, north side of Eldridge Pond. He didn't say he was using the pit prior to that. He said an existing pit. So a pit was existing. He didn't tell us whether he was using it before or not. And this is filed in August of '73. So when did he excavate this pit? He could have excavated it in the 7 months prior to that. It could have been a pit that existed in connection with the bog that was never used by him. Now he wants to take sand and fill in connection with his landscaping business. That's what that request was for. It was not a pre-existing pit. And as I pointed out earlier, this is something that I provided to Mr. Chesley in my package of materials. In the Superior Court case that these applicants have filed, they stated in that complaint, the sand pit has been in existence since at least 1973. They didn't say 1972, they didn't say 71, they didn't say 41. They said 1973 and was used by Clifford A. Deleuze and John Z. Deleuze as part of their excavation, trucking, and septic business. And they verified this complaint. They verified this complaint saying that to the best of their knowledge, for example, you have a statement by, a verification by Robert Deleuze. I believe that the statements made in the within verified civil complaint as to myself and my family are true and accurate. So, to the point that was made, this pit was being used for the first time in 1973. This is what they've told the Superior Court. That's what is evident from the application that was filed to this board in 1973. There's no pre-existing nonconformity. Any permit that they had in '73 expired in 1976. The second thing here that is very striking is the enormous expansion of the original pit. If there was any permit issued at all in 1973, it was for a fraction of what exists today. And if you look at the plan that was recently submitted to you, he has there on that plan the outline of what the original pit is. And if you look at the sketch, it's north of Briars Pond, which is now Eldridge Pond. This pit that we're talking about tonight, that is 9.4 acres, is westerly and northwesterly of Eldridge Pond. This is a completely different pit than what anybody was talking about in 1973. This has been just vastly expanded. And in terms of do they own it, I don't want to tread over again the ground that the previous speaker reviewed with you in terms of that deed in 1941. But as a starting point, when John DeLuz died, there was a probate filed for him in the Barnstable Probate Court. As some of you may know, that when a person dies, you file an inventory of the real estate that he owned at the time of his death. And in that inventory, the references, there's no reference made to any sand pit or anything of that nature. But what they refer to is, they refer to this 1941 deed, and they refer in that inventory to parcel number 3, if you look at the inventory. And that parcel, which the previous gentleman referred you to, talks about a cranberry bog on Briars Pond, and gives the boundaries, containing 3/4 of an acre. That's all. So I don't know what 1941, whether there's another 1941 deed that's floating around somewhere, but that's the 1941 deed that's referred to in the probate inventory from John DeLuz when he died, based on his probate, and that's 3/4 of an acre. By their own admission, on their own plans, they're excavating a site that's now 9.4 acres. Vastly different than what was permitted in 1973 by this board. And as to their ownership, according to the assessor's office, they can't assign a map number to this, or a parcel number, I should say, because they can't identify the ownership of this. They're effectively excavating on land that they don't own. And they're way beyond any permit that was granted in 1973, which has expired. There's no evidence that was a pre-existing non-conforming use whatsoever. By their own admission, in the statements that they've made to the Superior Court, it was commenced in 1973. And there is case law that I'll quote, which even if you were to find, and again, there's no basis for it, but even if you were to find that this is somehow a pre-existing non-conforming use, their expansion has been so broad that they would be required to come in for additional relief. And this is my final point. And I'll quote you from this decision, which is Oakham, ironically, Sand and Gravel Corporation versus the town of Oakham, in which there was an expansion of a sand and gravel operation. This is what the appeals court said. It said uses. It says Mass General Laws, Chapter 48, Section 6 provides that a non-conforming use of land, if lawfully created, is exempt from subsequently enacted zoning provisions. To preserve the protection afforded a pre-existing non-conforming use, any subsequent use of the property must not constitute a change or a substantial extension of the non-conforming use. That's exactly what we have here. We have a substantial extension. So, number one, the permit is expired. If they're relying on the 73 permit, that's gone. Number two, there is no pre-existing non-conforming use here. There's no evidence of that. By their own omission, it began in 1973. And finally, even if there is a pre-existing non-conforming use, they're way beyond what any pre-existing non-conformity may have been. And finally, there's no evidence here that they even own the land. And they need to have that as a precondition. They have to establish some standing in order to even be in here asking for relief. So I submit to you that the building commissioner was exactly spot on in his cease and desist order, and I urge you to uphold it. Thank you very much.
Thank you. We've had a lot of testimony, so if anybody else wants to speak, I only want to hear things that we haven't heard before. Let's not go over old ground here. Nobody. Attorney Shilley, would you like to just close up? But again, let's not rehash. If you have anything further to say,
I have a sense of the board.
I'll entertain a motion to close the hearing.
So moved.
Second.
Second, Mr. Donahue. I will entertain a motion in this case, Mr. Burke.
I'd like to move we take a brief recess. I would like to read the cases that Mr. Sabat cited on his case, which we can take even after the hearing is closed. You said you had copies?
I do, yes.
I'd like, if we could just have a brief recess for 5 minutes, I'd just like to read those cases before, is that okay?
Okay? Okay, we will recess briefly for 5 minutes, and then we will reconvene and go forward.
Chuck,
Braintree case
which
on
cases
Chelmsford.
do you have? Oh, okay, the ones you referenced. Oh, okay.
How about the last case you cited? Yeah, Oakland, was it?
I can get you that one. Yeah, I gotta do my. So there's,
This is not typical.
Okay, thank you.
Extension of
put these together.
More interested in the last case.
If you just, I'll tell you one case to read. I think I have it with me. Here. Here, I'm gonna give you that.
I've got three, I've got, I've got 3 other packages. So I don't know if I have one or not.
You look under the, you look under the beginning. Look under the-
No, you can stay there, that's fine.
And then you can about the special permits.
At town official, we used to have the planners in all the cases when it was Sue Levin.
That'll give you a lot of information.
You didn't know her, that was several planners ago. Her and the then chairman, Dick Fleet.
Oh, yeah.
Case with me. Say that I did.
Oh, yeah, I see that. Going down.
Well, that's what we're trying to get to, you know? All of this other stuff, that's where the town went. You own it or don't you? If you do, show us.
Tell you what you do. One of the things that will be very helpful. You have a computer? Okay. Go into the net, the wide net, and just put in Gale, Gale case, I believe it's G-A-Y-L-E or G-A-I-L, just Gale case
Oh,
zoning.
There were holes.
yeah, yeah,
Gale
yeah.
case zoning. Case is gonna pop up.
Oh, they've all taken turns to come in and lobby
It will,
one
if
by
you
one.
read the decision, I mean, you'll be educated beyond what you really wanna be, but
You
it's
know, they're all nice
great,
people.
well,
I don't have
permits, pre-existing non-conforming,
a bad word to say about anything.
variances.
Just,
Their land, they need to pay the back taxes.
right,
I
well,
mean,
it's important.
that's a good, idea of getting your feet into this, you'll see. That'll be helpful. This, reading the zoning bylaw helps some degree. Reading cases help.
That's right, they've been manufactured. They've been using it as a manufacturer.
Yeah, you can pick out pieces of it.
I was long trying this to really right over.
You are all set.
Shake everything
Right.
to do manufacturing.
Please, after that brief recess, thank you. The hearing has been closed. I will now entertain a motion on the case, please.
Mr. Chairman,
Burke.
case number 2017-18, the
No,
petition...
19.
No, 18 first.
Well, we said we were gonna carry that one, pull that one back.
Oh, you want to do 19 first?
Yeah, I think we should conclude
All
this
right,
one.
19. All right, I would move to deny the request to overturn the cease and desist order of the building commissioner, and in so doing, move that the board find that there's not been any evidence of a pre-existing non-conforming use established here, and that the evidence indicates that the permit issued in 1973 expired in 1976, and therefore there is no existing valid permit for this use.
Do I hear a second?
Second.
Second, Ms. Muller. All in favor?
Aye.
Aye. Opposed? Building commissioner's denial is upheld, 5-0. The appeal is denied.
Case 2017-18.
Next case. Yes.
Okay, I move that the petition of Jeffrey and Joseph Rigo to seek enforcement of their request, overturn or seek enforcement be denied, and that the building commissioner's determination stand, and on the basis that we find that there is no legal basis on which we may deny the use of JZ Drive to the use on the rear portion of the property, and I so move.
Can I have a second?
Second.
Mr. Donahue? All in favor?
Aye.
Aye. Opposed? Denied.
Thank you.
Thank you.
Thank you all. Thank you for all the time and effort you put in. Probably winners and losers, but I think everybody put a lot of time and effort, and the cases were well presented to us, so thank you all.
By the way, both council did an excellent job.
Yes.
Excellent.
I'm much more comfortable sitting in this seat.
Okay, Mr. Hedersted is rejoining the board. Thank you.
Absolutely. Oh, now the seat's nice and warm.
Was to get the commissioner
Thank you, Mr. Lauer.
on the building
Trenchard observation. Jeez.
Denied the petitioner's request.
So we're not going to require the building commissioner to enforce.
So what's the scoop?
They want
They denied,
Supported the building commissioner, and yes, we did not support the people on this.
did not support the people
you don't have the authority to do it.
Correct. We had no basis on which to
to close the road
limit
off.
the use of JZ Drive.
Okay.
For the operation that they can operate.
He withdrew the force agreement.
Okay.
Okay, so you record that in minutes. Okay, you got it.
Yes.
Force it. I gave it to
The case.
Okay, ladies and gentlemen, we need to move ahead here. Clerk, if you could call our next case, please.
Okay, next case, case 2017-31. This is a continued case. Damien and Cindy Texera have applied for a variance for a new dwelling built to a height over 30 feet. The application is pursuant to the code of the town of Harwich, section 325. Table 3, height and bulk regulations is set forth in Mass General Laws, chapter 40A, section 10. Properties located at 2 Fish and Game Drive, assessors map 77, parcel 15, C15 in the RR zoning district.
Okay, I will note, this is a continuation from our last meeting.
Excuse me, I think we're just asking for the people that were at the last meeting.
Well, it's not that easy, so let me just explain here.
I have one extra. I think you told us last time we would be missing one and before.
Right, at the last meeting, we had Mr. Donahue, Mr. Burke, Mr. Campbell, Mrs. Muller, and me, Ryer, as voting members. Mr. Campbell has left for Florida, so on this case, we will have Mr. Donahue, Mr. Burke, Ms. Muller, and me, Ryer, voting on this case. And we'll continue from the last time, if you could please, ma'am and sir.
Damien Texera. At our last meeting, there were 2 items that were requested by the board and for us to return them for your review. First was a letter explaining the unique topography, of which our engineer prepared a brief letter explaining this, which we just presented. Second was a proposal of cost to show what it would be to redo the roof and show that it would be a financial hardship on us. As you can see by the very detailed cost breakdown at $71,993, this would constitute a major financial hardship for us and resources we do not possess. As previously stated, this is our retirement investment vehicle, and we have gone all in on this to build this house, to sell to further our nest egg, so we may hopefully retire before 80. We luckily I've been able to hold on to our buyer pending the positive outcome of this meeting.
Sure, why don't you explain some of the numbers in the sheet you just submitted to us quickly?
The cost I prepared through my company, as far as you can see, all itemized, what it would be to remove the roof and put a new roof on. There's also, from my painting contractor, what it'd be to have everything repainted. From my heating and air conditioning contractor to remove all the heating and air conditioning equipment that's up in the trusses and then put that all back. From my drywall company to re-sheet rock the ceiling, skim it, plaster, and texture. From the insulation company to re-insulate everything. And from my electrician to remove all the electrical work and then replace all electrical work. And in my scope, of course, there's, cranes, because we had to put the trusses up with cranes, so we'd have to remove them because they're just too big to manhandle. The longest ones are 36 feet long, 10 feet high, and it's all right there.
Refresh our memory, what are we talking, 11 inches, was it?
Correct, yes, 0.9 foot, 9/10, yes, 11 inches.
Anything further?
I believe that's it.
Okay, Ms. Muller.
No questions.
We normally do not grant variances lightly, but I think you have submitted information to show the hardship, and we can be more lenient for minor dimensional what's the word I want? Dimensions in excess of the bylaw requirements, and I think 11 inches would fit that. I would support it reluctantly, but I would be willing to support it. Mr. Burke?
I guess I'm in the same boat. I feel reluctant to do this. On the other hand, it is a minor amount, and I think that this is something you as a professional contractor should have known better and got yourself into. But I would be willing to grant the variance based on the substantiation of the degree of hardship here.
Mr. Donahue?
Again, I join my colleagues. I am reluctant based upon the permit that was originally issued. But I am considering allowing it.
Any other member of the board like to comment? Yes, Mr. Hilliard.
I'm curious to find out that ultimately when I realize measuring the top from the ground to the top of a building is very difficult when you look at different towns have different methods of measurement. But ultimately, there's an agreement somewhere as to how you do it. You're measuring the four sides and so on and so forth. How did it happen that it was off by 11 inches?
Because there was a miscommunication and a misunderstanding on my part from the building inspector, because originally the plan was taller than what was allowed. It was drawn at 32.9, and what he did, instead of making me redo my plan to try to push things forward, because we were already at the 30-day mark, he said, just make sure that's 30 feet from grade, but he didn't use the term in the zoning is pre-existing grade, so about 5% of the house is in a low spot where it dips off, because as my engineer noted, there's a big dip. So therefore, that skewed when they did the average of the high-low of the pre-existing grade. Otherwise, we had presented at the prior meeting a letter that we were very careful that using the grade that came out exactly 30 feet, that's what he had certified at, but of course that was not from the pre-existing.
You changed the grade, not when you built the house, and
Yeah.
therefore after it was built, the
Correct.
measurement?
Correct, we just,
lower.
correct, sir, we leveled it off. We didn't bring any fill, and we weren't trying to, like, raise the house up to try to get a view of the ocean or anything. It was just a low depression on one side.
So in fact, from the foundation to the roof, it's 30 feet.
Correct.
But because of the grade being up a bit,
because of a slope in the
11
back,
inches
a slope in the back corner, just actually about 5% of the corner of the garage and a bump out for a breakfast room.
Thank you.
Anyone in the public like to speak to this case? Hearing no one, I'll entertain a motion to close the hearing.
So moved.
Second.
Hearing's closed. Any further discussion from the board? I'll entertain a motion on the case, please.
Okay, I'll move that we grant a variance, as the petitioner has requested, from the height requirements bylaw to permit the current house to be occupied. And in so doing, we'll find that there is a substantial hardship to the petitioner based, financial hardship to the petitioner based on the evidence presented that's caused by virtue of the topography of the property, that we can do so without derogating from the intent of the bylaw, and that doing so will not endanger the health, safety, or welfare of the public, and I so move.
Can I have a second?
Second.
All in favor?
Aye.
Opposed? Okay, your variance is
very much.
granted. Don't do it again, please.
No, we have the next house, same house being built, we're on it. Happy holidays.
Thank you, you too. Okay, Mr. Clerk, we're ready for our next
We're ready.
case. And
Case number 2017-32, also a continued case. Stephen and Joanne Churchill, through their agent, Attorney William Kroll, have applied for a special permit or in the alternative of variance to demolish and replace a pre-existing non-conforming single-family dwelling. Application is pursuant to the Code of the Town of Harwich, Section 325, Table 2, Area Regulations. As set forth in MGL Chapter 40A, Sections 6 and 10. The property is located at 17 Shore Drive, Assessors Map 78, parcel B15 in the RR1 zoning district.
Ms. Secretary?
Yes.
Would you refresh my memory who voted on this the last time, who our voting members were? I seem to have misplaced my sheet on this one.
I have it, if she doesn't. There was no vote.
No, but I wanted to have the same voting members.
Same four, Donahue, Burke, Ryer, and Muller. And Campbell, but he's not here.
Thank you.
These are the new plans.
Okay, since this is a continued case, we'll have the same four members, Mr. Donahue, Mr. Burke, Ms. Muller, and me, Ryer.
This one is 32, right?
And if you want to identify yourself for the record, Attorney Kroll, please, and who's with you, and
I'm Steve Churchill.
Attorney William Kroll from Harwich Port, and I have Steve Churchill and Joanne Churchill here this evening. Churchill is seated behind us, they're the owners of the property, and Harry Ellis is seated behind me, and he's the proposed builder. So if we have you four, just a reminder that we have to have a unanimous vote of the board to have the special permit granted. I did make a presentation last time, and I want to be brief because of there's more behind us, as you said earlier.
yeah, and some of them might be yours, yeah.
And some of them might be mine. So this was, you didn't like, for some reason, didn't like the plans that we submitted from coolhouseplans.com. So we had more new plans made by Chatham Drafting and Design. And I submitted those to Ms. Delaney today. You should all have those now. They show the front, right side, rear elevations, the floor plans, all that you requested, and the height of the building is 21 feet 8 inches. It's clearly less than 30 feet. I submitted also a revised certified plot plan because, as you can see from the front elevation, there's a little step that comes off the front. There's no front door. The front door is off the side. And on the certified plot plan, we had the southwest corner of the proposed dwelling was 8.5. So we included the step, and that's 7.6. So it would be going from an existing 15.1 It was gonna be 8.5. If you include that little step, it's 7.6. And the site coverage went from, increased to 9.3 from 9.1 previously. So nothing significant there. So it'd be the same argument under the Gale case to demolish and replace pre-existing non-conforming single-family dwelling, intensifying existing non-conformities, coming a little bit closer. Remember also, because of the septic system and wetlands to the rear, we're very limited as to where we could expand the existing cottage. But those expansions, as shown, or intensifications, in our opinion, would not constitute a substantial detriment to the neighborhood, and there would be no substantial increase in noise, traffic, fumes, odors, congestion, or the like, and we'd ask that you grant the special permit this evening.
Thank you. Mr. Donahue? No questions. Mr. Burke?
No question, I think the last time we weren't unhappy with the plans, they just didn't represent what was gonna get built, right?
Well, they were
This is
more
precisely-
artistic. They were more artistic. This is a little bit more graphic.
Nice way to put it.
This is
They were
more like
cool.
what
But
we're
this is
House
actually,
plans
this is,
custom
to-
what you see is what you get? This
Yes.
is it?
Yeah.
Okay, looks good to me.
Yes, and I agree, this appears to meet the requirements for a special permit under the Gale case. It looks like the proposed structure will increase the existing nonconformities, but not create any new ones, and it's not gonna be any, not gonna be substantially more detrimental to the neighborhood than the existing structure. Ms. Muller?
I know I asked this last month. Show me again on this where the 15 feet is that's going to become 7.6 feet.
Sure.
Oh, I see it.
See where the steps are on the
Yeah,
left
the
side there?
steps,
Yep.
okay.
Right.
No problem.
How was that measured as 15 feet at some point?
That was on the existing conditions plan, was 15.1
Okay,
for the existing house. So it's going from 15.1 to,
got it, thank you.
okay?
Would anyone else on the board like to pose a question? Is there anyone in the public that would like to speak to this case? Hearing no one, I'll entertain a motion to close the hearing on this case.
So moved.
Second? Second, Mr. Donahue. Any discussion? All in favor? Aye. Opposed? Special permit granted.
Thank you.
Thank you very much.
Mr. Ryder, that was just a motion to close the public hearing?
Yes.
Well, then, first that, and then that was, Ms. Muller made that motion and seconded by Mr. Donahue.
Grant?
Oh, wait, no, we didn't make the
We didn't.
I'm sorry. We didn't make the motion. I'm getting punchy here at the late hour. I will entertain a motion on the case itself.
We also move that we vote to grant a special permit on a finding under Section 6, Chapter 40A, to permit the demolition of the existing building and the reconstruction of the new building per the application plans, and in so doing find that the new building as proposed will not be substantially more detrimental to the neighborhood than the existing building or use, can be granted without derogation from the intent of the bylaw, and will be done without endangering health, safety, or welfare of the public.
Do I have a second?
Second.
Any discussion? All in favor? Aye. Opposed? All right. Granted unanimously.
Thank you very much. Thank you.
Thank you, Ms. Jayla. Getting punchy here. Let me stamp these plans in.
You're on a roll again.
Well, now we're moving.
Hold on a second, where'd my agenda go here? Okay. Tell me when.
Wait, Ray, you don't really need to hang around if you don't want to. You're more than welcome. Okay, you're more than welcome. Okay, Mr. Clerk.
Case number 2017-34, Pamela M. Williamson, trustee, through her agent Trevor Kurz, has applied for a special permit to construct an addition onto a pre-existing non-conforming single-family dwelling. The application is pursuant to the code of the town of Harwich, section Table 2, area regulations, and Table 3, height and bulk regulations, as set forth in MGL Chapter 40A, Section 6. Property is located at 65 Ginger Plum Lane, Assessors Map 2, Parcel G17, in the RH1 zoning district.
Evening, folks.
Hello.
My name is Trevor Kurz.
Wait, before we go, I have to designate voting members here. We will have Mr. Hilliard, Ms. Muller, Mr. Hederstet, Mr. Burke, and Mr. Capoli. You may proceed, please. Thank you.
My name is Trevor Kurz from Kurz House Designs. I'm here as an
Wait,
agent.
more volume.
I'm here as an agent for the owner, Pamela Williamson, in an effort to secure a relief by way of a special permit. More specifically, with respect to sideline setback and site coverage. If I could direct your attention to the site plan. I show in the left rear corner, the northeast corner, I show a shaded area, which is part of an existing deck, 10 feet by 7.8 feet, that we'd like to remove and square off the corner, essentially, with living habitable space.
That's it?
That's it.
Okay. Let's start with Mr. Capoli.
I have no questions.
Any questions?
None.
Let's see, Mr. Donahue, well, no, I'll just do the voting members, then we'll come back. Mr. Burke.
Okay, so the existing deck remains, is that being rehabilitated or anything demolished in this, or is it being,
The shaded area would go away in the existing deck.
they look to be slightly different in size.
Pardon?
They appear to be slightly different in size, or is the existing, you have an existing conditions and a proposed plan. On the proposed plan, is that just, that's the existing deck, there's no modification to it?
Correct.
I see.
Correct.
And you'll be putting a crawl space underneath?
Yes.
This is not gonna be full foundation.
Crawl space.
Crawl space, I believe, was shown on the,
Correct.
on the plan, all right. But it's completely heated and so forth, so in addition to the house.
Yes.
I have no other questions.
Yeah, I'm not gonna vote on the case. It looks like, though, it meets the requirements of the Gale case, but I would suggest to the board that we, if it's granted, we add a condition that there be no exterior demolition or construction or new landscaping between June 30 and Labor Day, 2018 and 2019. Mr. Hederstet.
I have no questions.
Ms. Muller.
I have a nitpicking little question about, we have an owner, we have an agent, and we have an applicant. Is it satisfactory for Mr. Kurz to be the applicant as well as the agent? Is that, here we use the term applicant. I just want to be sure our paperwork's in order. Is Ms. Williamson the applicant?
Yes.
So-
Yes, well, she signed as Pamela Wilson is the owner.
His
I know, but-
trustee, Pamela
As
Wilson.
trustee, yeah.
Pamela Williamson.
And she's designated Mr. Kurz as her agent.
But she remains the applicant, doesn't she?
Correct.
Yes. But I don't think
It's not a
that's a
defect that's
fundamental
gonna
error.
cause a problem?
Yeah, I don't
Okay.
think it's rises to the level of a major problem. I think we can waive that requirement. Mr. Hilliard,
I have no questions.
any other member of the board like to pose a question? Will anybody, is there anybody in the public that would like to speak to this case? Hearing none, I'll entertain a motion to close the hearing on this case.
So moved.
Second? Second. Closed. I'll entertain a motion in the case itself.
Through you, Mr. Chairman, the board hereby approves the application for a special permit to conduct an addition to a pre-existing conforming single-family dwelling. The applicant is pursuant to Code of Town of Harwich, Section 325, Table 2, Area Regulation, Table 3. Height and bulk regulation is set forth in MGL, Chapter 40A, Section 6. Property located at 65 Ginger Flood Lane, Map 2, Partial G1-7 in the RH1 zoning district, in accordance with the mooring engineering drawings. There are two of them. One is the proposed and the other one is existing, both dated 10/11/17, and 3 plans, although all 3 are dated 9/27, I'm sorry, 3 plans, all dated 9/20/17, and noted as P1, with the finding that the board finds this case meets the decision of the Gale case, and that there is no new conformity, and there will be no resulting substantial detriment to the neighborhood. In addition, contingent upon there'll be no major construction during the period 30 June through Labor Day 2018, and no significant external, you used the term,
New landscaping.
new significant landscaping during the same period. All of this is due to restriction of the roads, access to the property, et cetera, in the neighborhood.
Could you just make it apply to 2019 also?
Pardon?
Could you also make it 2018 and 2019?
I didn't go 2019, but I can, 2018 and 2019.
Just in case you don't start the thing on time. Okay. Is there a second to Mr. Hederstedt's motion?
Second.
Second by Ms. Muller. Any discussion by the board? All in favor?
Aye.
Aye.
Opposed? Special permit granted.
Thank you very much for your time.
Welcome,
Mr.
thank
Kurz,
you.
would you like this back? Can you use an extra set? Thank you.
Just let me stamp these. Should I stamp the existing? There's no need to stamp the existing conditions plan.
Not the
is there?
existing conditions.
Thank you. I'm gonna give you them all, I've got them all screwed up, so we'll unscrew them after the meeting. All right, Mr. Clerk.
Case 2017-36, Charles E. Alexander and Marie J. Alexander through their agent, Attorney William Kroll, have applied for a special permit or in the alternative, a variance.
Excuse me, Mr. Clerk, that's the wrong case, I think. We should be hearing Kenny, the Kenny
Kenny?
case.
88 Bank
Oh, I'm
Street.
sorry, yep, I'm one ahead, I'm sorry. Case 2017-35, John F. Kenny III and Bonnie Ann Kenny. Mr. Kenny must have been surprised, okay. Through their agent, Attorney William Kroll, have applied for a special permit or any alternative variance to change, alter, and extend a pre-existing non-conforming single-family dwelling by adding habitable second-floor space. The application is pursuant to the code of the Town of Harwich, Section 325, Table 2, Area Regulations, is set forth in MGL Chapter 48, Section 6. Property is located at 88 Bank Street, Assessors Map 14, Parcel W7B in the RM zoning district. That's the record.
Thank you, Mr. Chairman. Attorney William Crowell from Harwich Port, representing Jay and Bonnie Kenny. Mr. Kenny's seated here with me. Mrs. Kenny was here, but she just wore down after the first 2 cases and had to go home.
All right, before we go on, Attorney Kroll, let me just designate who's
Sure.
going to vote on this case. We will have, I guess, Mr. Donahue, Mr. Burke, Mr. Hederstet, Mr. Hilliard, and Ms. Muller.
Got it. We also have Steve Cook from Katuitt Bay Design is seated directly behind me. He's the building designer. This property is on Bank Street, before you get to Route 28. If you're coming down from Town Hall, it's on the right-hand side, probably 3 or 4 houses short of Route 28. And it's a, as you can see from the plot plan, it's a elongated dwelling that was kind of patchworked together over the years. The Sisters of the Good Shepherd used to live there in the last 20 years or so. Right. So we're praying that they are on our side tonight. There's not a substantial intensification of the pre-existing nonconformity taking place here. You can see from the plot plan, the southeast corner of the dwelling is 24.3 feet from Bank Street. So it's supposed to be 25, which makes it pre-existing non-conforming. And the Kennys want to put a second floor on, so in that little corner of the house, that will constitute habitable space within the 25 feet. So it's a Gale case situation as a result, and we're seeking to intensify that first floor habitable space by putting second floor habitable space above it. Also, they want to put, where it says new roof over platform on the Bank Street side of the house. That will be 23 feet from Bank Street. And because the house is already less than 25 feet, again, it's a intensification of the pre-existing nonconformity by adding the platform with the roof over it. The northeasterly side of the dwelling is 16.6 feet from the northerly lot line. It's supposed to be 20, so again, it's pre-existing non-conforming, so the second floor habitable space will also be an intensification on that side as well. The building coverage presently is under the 20% requirement and will remain under 20%. The site coverage is over the existing maximum of 35%. It's at 43.6, but we'll only be increasing that slightly to 44.8 as a result of the second floor addition. We have the denial letter in the file from the building commissioner, and we're seeking a special permit pursuant to the terms of the Gale case on the grounds that there would be no substantial increase in noise, traffic, fumes, odors, congestion, or the like, and there would be no substantial detriment to the neighborhood. It will remain a single-family dwelling. And we'd ask that you grant the special permit this evening. Thank you.
Mr. Capoli?
No questions.
Let's see, who else is voting? Mr. Donahue?
No question.
Mr. Burke?
And one thing I liked is you kept the building fairly low, 23 feet. It's, you get so much mass in the new buildings, it's really nice to see. It'll fit in Bank Street pretty nice, I think. It's a nice design. Yeah. I don't have any questions.
It looks like from the plan, there's only one bedroom in the house.
On the first floor.
We have a 7-bedroom septic capacity.
Okay, but on the plans, I'm only seeing down on the first floor, or are these plans
Just for the renovated
Not the whole
section.
house.
Right, because they're not going to be doing anything back here where it angles off. So we just had the plans show where the activity is going to take place.
Yeah, if I may,
There's more
Steve
bedrooms.
Cook from Katuitt
Okay,
Bay
now that, I don't,
Design. The bedroom's all in the rear section.
okay, the site
That
plan
not shown. yeah.
doesn't really show where the activity is. That was my second question.
The site plan does
Missing it?
not, but the building plans do. Okay, so
Well-
where the property angles
Right there.
off.
One right there and one over there.
No, it's going back, it's going to the left. We're putting a second story on to the left here someplace. How far down is it going?
Right there.
Just gave the plans to the
Does it go down to where that slate walk comes off the new porch?
Says new roof over platform.
Yeah, that's only part of it though, Dean. They're
Then you
putting
go the other side.
They're putting all of this on.
Deck over patio. Isn't that the other one?
They're putting all of this on.
You have the site plan where the deck is, halfway down, halfway in the middle of the property there?
Yes,
Middle of
slate
the house?
walk.
Oh,
coming
new
off it.
porch?
Two slate walks coming off of that deck there? Two-thirds of the way back?
Where the deck is, yes.
Okay, so it's going to approximately there, the second floor.
Correct.
Okay.
And then, and I asked Mr. Cook to prepare an existing conditions plan in case that came up with the Board of Health or with you folks. So I have that. I'm counting 1, 2, 3, 4, 5, 6, 7 bedrooms total.
Okay, no, I didn't realize this plan was only the expansion, because when I went down there and looked at it, it's something, I said, how could it only be one bedroom? The thing goes on forever.
Where the building angles off, there's 4 bedrooms back there where the good sisters were.
Okay. No further questions, Mr. Hedersted.
I have no questions.
Who else is voting here? Ms. Muller?
No question.
Mr. Hilliard?
No question.
Anyone else on the board have a question? Would anyone in the public like to speak to this case? Hearing no one, I'll entertain a motion to close the hearing.
So moved.
Second. Hearing is closed. I'll entertain a motion in the case.
Through you, Mr. Chairman, the board hereby grants a special permit to change, alter, and extend a pre-existing non-conforming single-family dwelling by adding habitable second floor space. The application is pursuant to Code of Harwich 325, Table 2, area regulation is set forth in MGL 40A, Chapter 6. The property is located at 88 Bank Street, map 14, partial W7-B in the RM zoning district, and in accordance with the site plan by Warwick and Associates dated, hello, September 30th, 2017.
Nope, September 20th, I'm sorry.
September 20th, 2017. Drawings A1 through I think it's A3.
A4.
A4 and EX2. And,
Dated, give us a date.
there's a date on these, I think is 10/10/207?
Yes.
On all of them, correct? No, yeah, 10/2/20, no, 10/10/207, except for
207.
EX2 is dated 10/2/17.
I'm sorry.
It's
And-
2017, not 2007.
17.
Right.
Okay, and
And if I may, while I'm interrupting, I apologize, could we also add in not just second floor space, but the roof over the platform?
a new roof
I will-
over the platform on, close to Bank Street?
Thank you.
And isn't there one, a deck above the patio? Or is that an old one? On the back?
That's not new.
That's not new?
No.
Okay. All right, so including the new roof over the platform adjacent to Bank Street, and the court, and the board finds that the case meets the decision of the Gale case, that there is no new nonconformity created, and there will be no resulting substantial detriment to the neighborhood. And with the addition that no major construction should take place during the period June 30th through Labor Day 2018, nor no new significant landscaping during the same period.
How about include 2019?
I don't think they're gonna need it, are they?
I don't know.
2018?
Put it in there. I'm not sure.
They've agreed to it in case they need it, yeah.
You can add 2019 if you want, that's fine.
Do I have a second?
I'll second.
Okay, Mr. Burke. Any discussion? All in favor?
Aye.
Opposed?
Thank you.
Granted.
Thank you. Thank you all for your time.
Oh, boy.
All right, Mr. Clerk.
Case 2017-36, Charles E. Alexander and Marie J. Alexander, through their agent, Attorney William Kroll, have applied for a special permit or in the alternative a variance to construct an addition onto a pre-existing non-conforming single-family dwelling. Application is pursuant to the Code of the Town of Harwich, Section 325, Table 2, Area Regulations. Table 3, Height and Bulk Regulations is set forth in MGL Chapter 48, Section 6. Property is located at 62 Clearwater Drive, Assessors Map 72, Parcel W86 in the RR zoning district, and that's the record.
Attorney Kroll, if you could identify yourself for the record, please, and sitting with you. And on this case, we will have voting. Let's see. We'll have Mr. Burke. We'll have Mr. Capoli, I guess. Mr. Hedersted, Mr. Hilliard, Ms. Muller, and who else? Is that enough? We got 5? Okay.
Thank you. Attorney William Kroll from Harwich Port, and I'm here with Charles Alexander, seated next to me, and his wife Marie Alexander is seated behind us. Also, again, Steve Cook from Katuitt Bay Design is the building designer, and Kevin Blute is here. He is the owner of Schoolhouse Construction and the son of Mary Lou Blute, who might have been some help in the first case because she was the building department secretary back in 1973.
And where is she, in heaven?
No, she's at Country Meadow Condominiums.
Why didn't she come? Let's do it over.
She was the one behind a cruel trick played on me one time because I was, for some reason, coming up to the Brooks Academy to file Board of Appeals applications at 5 minutes of 11 in the morning when the deadline was 11. So one day I got there and the door was locked to the whole building. And I'm there pounding on the door, and the town engineer, Marty Moran, and Kevin's mother, Mary Lou, and Jim Moore, the assistant town engineer, were laughing hysterically in the other room because they had locked the door on me.
Barely remember it.
No, barely remember who was involved. I will get her back at some point. So, in any event, this property is on Bucks Pond, and you have a certified plot plan that again shows some additional habitable space. One correction on my petition, I mentioned in 2 places, second floor habitable space. It should be first floor habitable space. There's not going to be a second floor constructed. Originally, that was the plan, but that's not happening. It's just the first floor. They're putting a foundation underneath, and there's a proposed retaining wall on the northwest corner. That proposed retaining wall will be 9 feet from the lot line, so that's an intensification of the existing nonconformity along the westerly lot line. And then you see the shaded-in area on the proposed conditions plan that says open foundation and squaring off the corner of the house. That's creating first-floor habitable space. So it's we won't be coming any closer with the house, or the addition, no closer to the lot line than the existing dwelling. But since we're less than the 20 feet, we're intensifying the southwest corner by adding habitable space and squaring off the house, and coming somewhat closer with the retaining wall, which, as you know, is a structure under the bylaw, so we need relief for that as well. The building coverage and site coverage will remain under the 15% and 25% respectively under those maximums. And Mr. Chesley has issued what we call a denial letter in this case, referring us to this board. And we would argue for the special permit pursuant to the terms of the Gale case. Again, no substantial increase in noise, congestion, fumes, odors, traffic, or the like, and no substantial detriment to the neighborhood. And we're going to remain a single-family dwelling, and would ask that you grant the special permit this evening.
Okay. Mr. Mr. Burke.
I don't have any questions at this time.
Mr. Capoli, sorry, Mr. Capoli.
I don't have any questions at this time.
Mr. Hedersted.
I have no questions. It looks like it meets the Gale case provisions.
Mr. Hilton.
No questions.
Ms. Muller.
No questions.
I only have one. What do you mean by open foundation? I'm not sure I know what that is.
I'll defer to Mr. Cook on that.
Steve Cook from Kentuit Bay Design. You talking about the front addition?
Yes,
Yeah.
open foundation.
Because the septic system is very close there, we couldn't do a foundation. But the health director said it would violate the Board of Health regulations if we did a foundation because it's so close to septic tank and leach field. So that whole front addition will be on Bigfoot sonotube footings.
Okay,
So we'll probably have like a Durarock board or something underneath it, but it won't have a concrete foundation.
okay, thank you. Is there anyone in the public who would like to speak to this petition? Hearing no one, I'll entertain a motion to close the hearing on this case.
So move.
Second?
Second?
Hearing's closed. I'll entertain a motion in the case, please.
Through you, Mr. Chairman, case 2017-36. The board hereby grants Charles F. Alexander and Marie J. Alexander a special permit to construct an addition to a pre-existing non-conforming single-family dwelling. The application was made pursuant to Code of Harwich, Town of Harwich 325, Table 2, Area Regulation, and Table 3, Height and Bulk Regulations set forth in MGL, Chapter 40A, Section 6. The property is located at 62 Clearwater Drive, Map 72, Partial W86, in the RR zoning district, and in accordance with the Moran Engineering Associates drawings, plot plans rather, dated, there's two of them, dated 10/12/2017. One of them is existing and one of them is the proposed. And the floor plans also provided by Kentuit Bay Designs LLC, all dated to 10/9/2017, drawings A1 through and including A7. And the board hereby grants the case based upon the fact that it meets the decision of the Gale case, in that there is no new conformity being created, and there will be no resulting substantial detriment to the neighborhood. And I believe it is very crowded residential area, so no major construction or significant landscaping is to occur during June 30th through Labor Day in 2018 and/or 2019.
Could I have a second on that motion, please? Second, Mr. Capoli. Any discussion? All in favor?
Aye.
Opposed? Special permit granted.
Thank you very much.
Thank you.
Jesus, I'm getting sick and tired of him. We gotta get somebody new. You know what, I wanna get a piece of that action.
What?
Can we order up the food?
That's a good idea, Randy.
Oh, this is the,
This is as bad as a 40B night.
I think it's worse. I don't think
You know what's,
they're
you know what's
gonna
terrible? I go to the Natick Planning Board.
when he used the
board
use the
sits there,
term
you know
Gale,
what they got? They have a buffet behind them.
the term Chase House, that really threw me.
And while the applicants are making
But
their
it's
case.
down next to.
No,
Oh, it's awful.
next to, but it's not the normal Chase House that we just got
All
through.
right. Next case.
Case 2017-37, Virginia Chamberlain, through her agent, Attorney William Kroll, has applied for a variance to construct a full foundation under a pre-existing non-conforming single-family dwelling. The application is pursuant to the Code of Town of Harwich, Section 325, Table 3, height and bulk regulations as set forth in MGL Chapter 48, Section 10. Property is located at 87 Route 28, Assessors Map 10, Parcel W3, in the CH1 zoning district, and that's the record.
Okay, I think Attorney Crowell will have our regular members vote on this one, Mr. Burke, Mr. Hedersted, Mr. Hilliard, Ms. Muller, and me.
You just jot that down.
Now, Burke, Hedersted, Hilliard, Muller, Ryer.
You've got the chief.
Thank you. I have it.
You know I love variance cases.
Now we're here, what we're waiting for. So, I'm Attorney William Crowell from Harwich Port. I have, seated to my left is Virginia Chamberlain, who's the owner of the property. I have Dave Little from Ryder and Wilcox Engineering, and also in the blue shirt, Mark Grant from Quality Construction. And I was here last month. I was also here earlier this evening and heard your attitude towards height variances, dimensional variances. I'm going to ask you to expand your minds and be open to this case because it's worth your consideration. I know it's late. I know you're tired, but it's worth your consideration. There's a lot at stake for Ms. Chamberlain and possibly for the town of Harwich, if you can see your way to grant this variance this evening. If you haven't seen the property, I do have pictures, a picture of it.
Thank you, sir.
I don't have enough, so you'll need to share if you would.
That's okay, we can, I know the property.
Right, it's in a
We know it
neighborhood
well
we've-
from the
where
40
we've
B.
visited.
Believe me, we know this property.
I just looked at your narrative, it's a Chase House, not the Chase House, which we are very familiar with.
Of Chase and Sanborn.
That's
Is that right?
exactly
Yes.
right, yeah.
Yes.
Yeah.
The Exchange Hall Square here, Exchange Hall was built by
Mr. Chase.
Mr. Chase of Chase and Sanborn Coffee, back in the 1800s. So this house, which you can see is a substantial house, it's on Captain's Row in West Harwich, one of the Chase houses. And we're seeking a variance tonight from the 30-foot height requirement in order to put a new full foundation under the pre-existing non-conforming single-family residence that was constructed in 1866 or thereabouts. So it's historical. We've been to the Historical Commission. They said if the variance is granted and you put the foundation under, whatever shows has to be brick veneer or brick on a concrete foundation so that it continues to have that historical look and character. And the Conservation Commission has said they don't need to take jurisdiction, even though this is in a floodplain zone. There will be no change to the footprint of the existing dwelling, and at this time, no further alterations other than interior utility work. The existing, so let me try to explain to you why we're here. And I've got the engineer here, and I've got the builder here, but I'm gonna try very hard not to get everybody confused with numbers and floodplain elevations and all that stuff, all right? So to keep it simple, so that I can understand it, in 2014, Barnstable County adopted the new federal flood zones. And this town then subsequently adopted that as part of its bylaw, and that those new floodplain zones make buildings, houses like this, non-compliant. All right? So let me just touch on the height calculations. If you calculated the height of this building in accordance with the way our bylaw was, this building would be, prior to the way it was prior to the changes, this building would be 31.8 feet above average grade. It would be a pre-existing non-conforming dwelling as to height, and we got under the Gale case, seek an intensification of that under special permit requirements and not be begging for a variance, all right? Now, with the new floodplain zone elevation, calculate it, it sounds contradictory, but with the new floodplain elevations, we are only 29.7 feet. So we're not over the 30 feet, and we want to go over the 30 feet, so we need a variance and not a special permit. The change in the flood zones were dictated by FEMA. That created Ms. Chamberlain's problem. She didn't create it. FEMA did, and the change in the law did. And the change in our bylaw created it, not her. Her predicament is that if she does nothing, then she has to buy very expensive flood insurance, which could be anywhere from $3,000 to $15,000 to $20,000, depending on the property. It's very expensive, and it affects her value as a result. It affects her mortgageability. She didn't get a mortgage when she bought the property. If she gets a mortgage, the bank's going to require flood insurance, very expensive. It affects her saleability. If she puts it on the market, she may lose a third of her potential buyers once they find out expensive flood insurance. So I'm obviously talking about a financial hardship if she does nothing. She has to buy flood insurance, or her buyers have to buy flood insurance. Her dilemma then is, she says, okay, then how do I avoid flood insurance? If you lift the house, that's FEMA calling them. If she lifts the house to meet the flood plain zone requirements, then she would not need flood insurance anymore. However, if she lifts this house, she needs a variance from this board. I have for you to consider, because I know you want some figures on what it would cost. So I had Mr. Grant from Quality Construction Corp. Come up with this estimate of if we're not going to, with a historical house, we're not going to cut off the top of the roof. He would have to take the roof off of the house, repitch it, which is not going to look good to the historical commission people. It's going to take away from the character of the house, but repitch it with new rafters and all of that, and it's just shy of $80,000. Again, financial hardship issue. If she does nothing, she has to buy flood insurance at some point, or her buyers do. If she takes some action, she needs to either get a variance from this board, or she has to spend $80,000 to repitch the roof, and the historic commission might say, foul, no, you can't do that to that house. So she's caught between a rock and a high place, pun intended. So she wants to renovate the house. She wants to restore this house. You can see from the picture, it's in, with all due respect, it's in fairly dilapidated condition, needs to be restored, and she wants to do it, but she doesn't want to spend $80,000 on the roof, and she doesn't want to sit there and do nothing and have the house deteriorate further, because if she does renovate the house, she would start, anybody that restores houses or isn't in construction knows that you start with the foundation. You put the house, just like the Bible says, on a rock foundation. Make sure that's solid, then you put a new roof on so it doesn't leak anymore, and then you worry about the rest of the house. She happens to have a house that's already almost 30 feet.
It's over 30 feet.
So she wants to start with the full foundation. It is right now, it's on a rock and brick foundation that compromises the structural integrity of the house, as I pointed out in my petition. So I had Mr. Grant give us a paragraph that I'll hand out to you. That says that if we just put more rock and brick to raise the house 2 feet 6 inches to meet FEMA requirements, that it would not have enough lateral strength to support a 2-story structure anymore.
Thank you.
And it needs to have a level base with which to start the restoration process. So he's saying, and Mr. Little from Ryder Wilcox also told me, if you lift this house and then try to put it back down on that same type of foundation, it's going to implode, it's going to crumble. It's already got uneven flooring, it's going to make the uneven flooring even worse. She wants to do it right, but FEMA's getting in the way. So this is the way I look at it. It's a simplistic way to look at it, but I'm not going to try to convince you that we don't have to lift the house 2 feet 7 inches. We do. And when we're done, it's going to be 2 feet 7 inches higher physically than it is today. However, it's on a big lot. It's on 2.66 acres, 2 2/3 acre lot. And if you look at that picture, if you know the property, it's low. It's lower than Route 28. Topographical soil conditions are low, okay? And Mr. Grant has come up with a great idea, which is that with that big lot, the plan is that he would feather by bringing in fill, not from Duluth's sandpit, but bringing in fill and feathering it, okay? So that when we're done with the 2 foot 7 inch lifting of the house, when he's done with the grading, you would only have 12 inches of brick showing of the foundation. And it would look from the streetscape, it would look the same, if not lower, because right now it's 16 inches. This would only be 12 inches of brick. It would look the same. You wouldn't know that it physically is 2 foot 7 inches higher. But the good part of all this is it's on 2.5 acres. It's not blocking anybody's view. It's not in the way of somebody's ocean view or anything else. It's an existing historical house that's almost 30 feet, a little over 30 feet as it is. It's not going to bother anybody. It's going to look the same when he gets done with it because of the feathering of the fill around the lot. So, again, to just be straightforward and keep it simple, Ms. Chamberlain has a financial hardship that she didn't create. The change in the law, the change in our bylaw created the hardship. It's a financial hardship because if she does nothing, she's going to have to buy flood insurance. She doesn't want to do nothing because she wants to renovate the historical character of this house and bring it back. If she raises it without a variance, lifts it without a variance, she's got to spend $80,000 minimum to retruss the house, which seems kind of unnecessary, let's say. So she's got topographical conditions, not created by not of her own doing, due to the soil conditions of this new floodplain elevation requirement, due to the topographical conditions, if it's low-lying to start with, below Route 28, and the structure itself, the size of the house. Height is part of the size, when the statute talks about shape, size, topography of the house, of the lot, or the structures on the lot. Size, it's already almost, it's a little over depending on where you start again, but it's around 30 feet right there, and it already exists. It's not like the previous Texera case where it's a brand new house. This is 1866. We don't want to be messing around with that roof of that house. It's just not going to be the same. And as Mr. Grant has pointed out, the carpentry and workmanship on that house is very, very good. They put a lot of time into it back then. What you call it, flying rakes?
Yes, flying rakes.
Flying rakes, jutting out, all kinds of cool things that historical folks like. If this board could see its way to granting this variance in this very unique situation, there would be, in our opinion, no substantial derogation from the intent or purpose of the bylaw. It would not be blocking anybody's view. If you look at why do we have a height limit? You don't want to block somebody's view. We're not blocking anybody's view. I don't foresee it in that immediate neighborhood that we'd be blocking any view of anything. It's a historic house that already exists and needs to be renovated. So that all fits in with the intent and purpose of the bylaw. This situation cries for a variance. We're talking about historic preservation versus federal regulations and height requirements. And I think you need to balance what's more important, the historic preservation of this beautiful house that needs the work. I think it's also important as a town that we be user-friendly to our homeowners and support them in trying to renovate houses. And if you look at the West Harwich blight, which starts a little bit beyond Herring River and goes to almost to the traffic lights in Dennisport, and this came up at the annual town meeting last spring. What are we gonna do with the West Harwich blight, that whole strip along there? This is a start. This is, you could go house by house, block by block, and try to overcome that West Harwich blight building by building if you grant this variance this evening. Thank you.
Good thing you went at the 40B hearing and used the term West Harwich blight. You wouldn't have escaped alive.
It's a
I'm just
charming
repeating
area.
what I heard at the annual town meeting.
Yes.
And if you remember, Mr. Kukunis said that his tractor broke down, his farm tractor broke down, and he couldn't, nobody gave him a ride, and he had to walk that whole strip. And he says, I can tell you, it's blighted over there.
Bishop's
The neighbors
Terrace
disagree, but
Bishop's
Mr.
Terrace is going like
Blowing
this.
right in on it.
Yes, we heard it was far different, but for many, many sessions. Go ahead, Mr. Bird.
Okay, I get to start. Well, unlike the Texera case, I think this is a very appropriate case for a variance. I think it has all the pieces. It's nothing like the other case at all. You know, in section 10 of 40A, we always focus on, you know, shape, topography, and soil conditions. It has 2 out of 3 of those, but also, you know, it also says for the structure. And you can read that, there's no case law one way or the other on this, but one can argue that the structure alone, unique conditions of the structure alone can justify a section 10 finding. There's no case one way or the other on it.
Right.
And,
Very
you know,
rare.
I think if they mention structure, it's kind of crazy to say the topography or size, you know, applies to the structure. And I think this is a very unique structure. It certainly has the circumstances about the structure just by itself, never mind soil conditions and topography, certainly create a hardship, a financial hardship. It doesn't mean the house can't be used, but the amount of degree of variance that you're looking for here, I think, is fairly modest. And I think I would totally concur that what you propose completely blends in with what is there. I don't think you will perceive a big change in
You
this.
won't notice, other than, boy, the house looks great.
You know, and the financial part of the flood insurance too, and that's not just 20,000, that's per year.
I'm sorry, yes, it is
It's
an
not just a
annual. Yeah,
one-shot
yeah. It could be
deal.
$5,000 a year,
This
which,
goes on
the
and on
bite.
and on. And the other part of it is, I think that it's a hardship in the sense that you just, you know, if you don't repair this building, it's gonna be just demolition by neglect.
Right.
And so it's not a matter of just, I got banged with that bad insurance premium. I can't legitimately repair and maintain the house. And, you know, I once owned a house that had this kind of age, and you know these things are money pits. There's no end to the renovation that goes on with these buildings, so you have to keep ahead of them. So anyway, I'd be inclined to grant more than inclined, grant a variance
Yeah, I
as
would too,
requested.
even though section 10 really doesn't talk about size. It talks about the shape, topography, but I still think.
But section
I-
10 also says, or structure. And the question is whether or not
I
shape,
think it says shape, topography,
That's why I said shape is size.
size, but keep going,
shape, topography of land or structure.
or structure. Now,
structures.
the question
Right,
is,
but-
the shape, topography, and the soil conditions
Soil conditions.
are not necessarily related to the structure. You can carefully read that. There's a lot of argument about that in section 10 as to whether or not that "or" means you can stand only on the structure's unique conditions, and there is no case law one way or the other.
Right. But I'm not gonna read it that strictly.
But anyway, I
But-
think you got all the pieces.
Thank
Yes,
you.
I agree. I
Of
think
an
this is-
impossible statute to meet the requirements of.
I think this is unique. However, if the board sees fit to grant a variance, I would like to see 3 conditions, which basically were in the narrative. We would want the lot to be regraded after construction to minimize the visual increase in height, which is already in there. We would want only 12 inches of the new brick foundation to be showing above the end grade, again, in the narrative. And the new thing, I think, excuse me, we'd like to see evidence of compliance with these 2 conditions to be submitted to the board within 30 days after substantial completion of construction. And I think that's fair that we see that, because we have, to our regret, well, to my regret, I think, Mr. Hederstat and I are the only 2 that are still left, granted a variance where we didn't ask for that, and we've regretted it ever since, the one on Bay Road.
What was the last statement you wanted them to come back at you for?
They'll come back to the board within 30 days of substantial completion of their construction and show
Why?
us that they've met these 2 requirements. That they've graded it to minimize the visual increase, and there's only 12 inches
That
showing.
doesn't come back to us, goes back to the building inspector. Why do
What
we,
you-
we're not acting as a building
What you
inspector.
could do is provide that no occupancy permit will issue until the building inspector has received from the applicant.
Yeah, don't put yourself in that
Those
position.
things
Well,
will
they
give us
put us
back-
all in
back
that
to us.
position.
Don't put yourself in that position.
No,
Let the
okay.
building inspector do
Yeah,
his
let it-
job.
let it
Okay,
go.
that's fine.
That's the
Well,
only
whoever
reason
makes the motion, so note that. Ms.
Okay.
Muller.
I
No
got a,
quest-
Oh, I'm sorry, Mr. Hedersted, I passed him.
yeah, you know, it's unique. You're already over the height. You know, so what caused you the problem? It ain't the house. It's the town, which they adopted and the town, when they adopted that says that you're in a zone that is, AE, I guess it is, or A something.
Yeah,
AE, and they have to have 11 feet, you get 11 feet height. So that, subtract that from where you are, from the existing ridge of and you are now 29.7, and you gotta go up. You gotta put it an 8-foot Sullivan, 8 foot from ceiling to bottom?
7'9", I believe.
Go ahead, Mark.
We're not sure if FEMA will allow us to do that. They will be our next step. To put a foundation in a flood zone, it has to be normally a crawl space with flood vents, is how we're understanding it. So we're not sure if we can put a full basement, but if we can put a foundation that has the flood vents that will shore up the house and give it a good foundation to sit on, it will get the first floor of the house up and out of the flood elevation, which is flood elevation
what I was
11.
after,
The floor of
okay.
the house will be at elevation 12 or 12.3.
Whatever, right, okay, good.
So that is what the intent is.
That's what, okay, I understand now. So, and if it happens to be, you happen to luck out, it would give you room to put some of your, you know, heating and stuff like water and all that stuff
Exactly.
down there, where it's upstairs now, I assume. Or, we got a crawl space?
There is no heat. Dirt. Well,
Dirt crawl
that's
space.
one of the things she's proposing to do is put a new heating system in the house. There is a
What is
few
used for
existing
heat
heaters
now?
throughout the wall. There's a few existing heaters in various rooms, but that's it.
Okay, I won't go into it.
If I may, Mr.
understand.
Hederstat, one of the things that I'm going to be doing is submitting a request for a letter of map amendment when placing fill on the lot from FEMA, which I expect to get for the applicant. And that will allow them to have a full foundation, because we're gonna be creating a grade that will no longer allow the flood zone to touch the walls of the foundation.
Good. Good, good. Yeah, I think you need it. And so, under those conditions, you know, a variance is cried for, there's no question about it. Tears are running down my eyes. But, you know, and I think it does, there is a hardship here, absolutely, and it's created not by you, but the town. And so, and it's not the shape, but it is the topography and it is the soil. That's what's causing the problem. That's what you're sitting on. You can't help that. So therefore, in my estimation, it meets the criteria for a variance without a question.
Ms. Muller,
No questions, no comments.
Mr. Hilliard.
I thought you were gonna talk yourself right out of this one. I thought you were gonna talk yourself right out of this if you kept going. No, good job, I agree.
Thanks.
Anybody else? Any other
I was gonna
board
stand
members?
up and clap, but I didn't.
Yes, Ms. Mayhew.
And I don't know if this is for the board or if it's for Attorney Kroll, but what would be the concern if there's a financial hardship with the flood insurance and not being able to repair the home in another way or take off the roof or all that? What's the concern that we'll get this house lifted and run out of money? Like, my question is, like, how do we guarantee if it's a historic building and we're granting a variance to lift it, how do we know that that's going to happen?
We don't.
Okay.
We don't,
With
and
any
anytime we
petition.
grant
It's
a
a good question,
variance, I mean, it's an excellent question, but we don't. And this is historic, like with a little h. It's not on the National Register of Historic Places or
Okay.
anything. It's an old house. It is historic in that sense. But I don't think we've ever put a condition in the variance. I mean,
okay.
if they do it, we have it all the time. Attorney Kroll recently asked for an extension of a special permit because his folks didn't have the wherewithal economically to do whatever, I don't remember what the thing was, three apartment.
That has changed drastically in the last 2 weeks.
Right, and the permit expired. But, you know, they can refile.
Okay, so there's no bonding or anything like that to be done with any?
No,
Okay.
it's actually, I mean, they're the ones that would suffer. And
Well, so with the blighted area,
Well,
that would be bad.
we have a blighted house now, and then we'd have a blighted house
well, it would look like
on a nice
the
foundation.
Okay,
Chase,
okay.
like the Chase
The
house
Chase
down the
house,
street.
exactly.
Okay, thank you.
Just one last question. Why could we not do this as a special permit, as an intensification of a non-conforming?
Because of the change in the bylaw.
We're required to measure our height from the flood zone, because we're in a flood zone
Okay,
now.
but it was already under the existing law over the height, so aren't we
But
just-
not now.
Not now.
Oh, I see what you're
We
saying.
did get, we got a denial letter from,
Okay, I see what you're saying. The new,
It's
under
kind
new
of a,
formula.
it's a
it's
strange
the
thing
same.
to say, but yeah.
Non-conformity became
The
a
new
conformity.
formula becomes 32.4, that's what
Oh,
that
it's
is.
bizarre.
Okay, good, you've answered my
I talked to
question.
Mr. Chesley about this today, and he said he was not thrilled with the bylaw as it stands now anyway, because we have this situation.
Okay,
And we may run into this as we go along during that street, so.
well, I'm sure we will, in that whole area down there. Anything further from the board? Anything from the public? I'll entertain a motion to close the hearing.
So moved.
Second,
Hearing closed, I'll entertain a motion in the case, and don't forget those conditions.
Mr. Burke, you could take care of this one.
Okay, I move that we grant a variance to the applicant to for a height variance in order to raise the house as applied for. And in so doing, we find that we may grant this variance based on the fact there's a finding that there's a substantial hardship, financial hardship to the applicant based on the topography and the soil conditions and the unique circumstances of the structure, that we can do that without derogating from the intent of the bylaw, that it will not, be any harm to the health, safety, or welfare of the public, and on the further conditions that the lot will be regraded after construction to minimize the visual increase in the height of the building. Number two, that only 12 inches of the new brick foundation will show above grade, and that prior to the issuance of an occupancy permit, the applicant will submit to the building inspector proof of plans, as-built plans demonstrating compliance with those conditions.
Excellent. Second.
Seconded. Thank you, Mr.
All in
Burke.
favor? Aye.
Aye.
Opposed? Granted unanimously.
Thank you very much for considering all that, really appreciate it.
Well, you're welcome. It's a good project. It's
Kroll,
a
that
nice
was
house.
an excellent
I'd
presentation.
like,
Your client
I'd like,
should be
actually,
very
I'd like
happy
to
with
make,
you.
What's your fault? That's why I said we keep
Attorney Crowell, I'd like to make a further condition that she do the Chase House, you know, improve that down the street.
I know that house.
I don't know if she's got that much money.
No, it's just a shame seeing that just folding out.
We discussed that ad nauseum in our 40B, you know, the habitat.
Do you notice something? You notice what they've done here? When you go back and take a look at what the new construction going on with the affordable houses,
You should take the.
how do you think their septic systems look like? What do you think the height looked like in those houses?
They said they weren't in the flood zone.
They are in the flood
They
zone.
have to be there next to that.
They're in it.
I think so.
Yeah, they are. They are.
You were
They're
gonna
in it.
move your driveway, weren't you?
They're in it.
You were
Yeah,
gonna
they're
move
in
your
it.
Okay.
driveway or
Yeah.
something?
Maybe they were, I don't know.
No, they have
Yeah,
to.
but Title V
they
said
have
that
to
the
tear
septic
down
systems
the
would
first.
be in the flood zone, remember?
Title V said they were all right.
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 Because my lot and their lot is 2.66. They had said, do you want, can we put the road closer to you? And I thought, well, if the road goes up, you know, up to the section.
We got for next
I could
month.
branch off if I ever
One
wanted.
case.
One case?
Well, no, they're barely making that.
Plug tonight.
My house.
Okay.
Cutting in.
Shayla was enjoying the
Like,
ride.
well,
She was just
Okay,
like, oh,
we're not
God.
done yet. We're not done yet. We need to, finish up here. I'm getting tired. We need to finish up.
I'm beyond, beyond tired.
I'm thirsty.
It was, great job.
Okay, does anyone have any comments on the minutes from the October 25th, 2017 meeting? Anyone that
I
was
wasn't
there?
there. No comment.
Was not there.
No.
Okay as written.
Motion
I,
to approve.
Second.
I'll move that we approve the minutes of the October 25th, 2017 meeting as written. Good night, Ray, thanks.
Good night, Mr. Chuck.
Second, Mr. Donahue. All in favor?
Shayla, I thought you did a great job bringing it up.
Okay, Mr. Capoli, you had some changes on your info.
Oh, yeah, unfortunately, I spent the last month sailing an old wooden ship from Provincetown to Key West, and
We're supposed to feel
Yeah, that
really
doesn't
bad,
sound
really
bad.
bad.
Keep going,
And
it's terrible.
while I was out to sea, my website domain expired, and apparently they have these robots on the internet that they go and pick them up and then ransom them
Oh, okay.
for thousands of dollars. So that's actually my cell phone, but my temporary email, in case y'all want to email me, is just attorneycapoli@gmail.com.
Attorney?
All one case?
Yes, Attorney Capoli.
Distinguish.
What's that?
All righty.
The web doesn't distinguish between lowercase and uppercase.
not for address.
Oh, really?
Address.
Good to know. Okay, so it's Capoli. I've been using the hard C.
Capoli.
Capoli. Capoli.
Yeah, it's like cannoli, but less delicious.
My wife loves it. I've never been a fan.
Yeah.
People were.
But I have a quick question as to, has everybody had, all of the new members, your ethics?
I've done it, I have to get my certificate though.
I have one from my fire department, but I have to get it in my personal file.
So supply those to
Anita.
the Anita.
Hey, mine is, you've got,
It's not a first name basis.
you've got mine, the old one. You don't have my new one in here. My new email address.
Sorry.
Which is?
Oh, that's right.
What's your new one, Dean?
What is it?
Ready?
Yep,
Go ahead.
everybody.
D-E-A-N.
Wait, too fast.
D-E-A-N.
A-N.
T-E-D-T.
T-E.
D-T.
Oh, God.
Dot.
Wait, T-E-B?
T-E-D-T.
D.
D is in Delaney.
T-E-D.
T.
T. Yes.
Dot 534 @gmail.com.
We'll never get an email
Sorry that I missed that.
You didn't get any space.
Dean and the end of Hedersted.
Putin is gonna punish you for that one.
Who?
Putin, when the Russians hack you.
Oh.
He's not gonna like that one.
Oh, forget them. They don't, the Russians can't hack me.
Okay, and one
got
more
me.
thing for me.
Did they get you?
Mr. Campbell is just in Florida, but he will remain on our ranks, on our list, because we,
Yes,
yes, okay.
Mr. Campbell should remain.
Mr. Campbell's gone?
He's going until,
Oh, okay.
April.
Yeah.
Okay, any other new business?
Only one case, for December,
Thank you, God.
Oh, yeah, yeah.
It's the 28th?
whatever it is, I forgot.
It's the
Yeah.
or 27th, I believe, I think it's the
Yes,
27th.
27th, that's correct,
27th.
yes.
Yeah, there is some, it's amazing you say that.
So how come you didn't
See
invite
this
me over
commercial
for
stuff.
Thanksgiving?
And then you see this
Okay, so the 27th of December,
Outrageous. You didn't have any more turkey left.
now,
The Irish pub. That was his summer home. Was it
wait a minute, guys,
Sorry.
next meeting's the 27th, but we only have one case, so there's no reason for everybody to show up if you don't want to. It's around the holidays. We should have 5 people here, though.
You wanna take this? Or should I?
I'll be in Texas.
I'll be here.
I'll be here.
1, 2, 3, 4, and I'll come. So if this side of the table doesn't want to, you're more than welcome to come,
Permission.
but you don't have to.
Okay, thank you.
It's up to you. It's around the holidays, people travel, so. As you saw tonight, we had a ton of cases.
We
So
are
it just-
closed, on the 26th, so anything you need to find out about, make sure you do it before the 22nd.
Oh, Sheila,
Okay,
And
and
turn them in, get refund, refunds? Yeah, otherwise, before you realize, you have a stack like
Okay,
And
I
wrap
will-
this up, there's a recycle bin here on the way out.
excellent.
I'll entertain a motion. What?
Can I just,
Mr. Burke?
can I have the floor for a second?
Mr. Burke? Wait,
I just want to
gentlemen.
tell everybody, this will be my last meeting.
Oh,
I'm,
no.
resigning from the board. It's not a bad thing. I've been, I'm a believer in term limits. It's been great. I've been on this board for, what, 5 years? 6,
Quite a while,
whatever, yeah,
yeah.
yeah. And I've loved it. Of course, it's kind of a busman's holiday for me because, you know, this is what I do. I'm usually on the other side of the table. And after all these 45, 46 years of doing zoning in front of towns and so forth, I've decided to start to retire next year. So this is part of my,
So this is the last meeting, or you're?
well, I was gonna wait another, if we had a continued case, I was gonna stay on until it was done. I didn't know what this pit thing would end up, I would've stuck it out, but we only have one more meeting, and I was thrilled to see we have some great new members. That's fabulous, because that was a problem when I first came on the board, was we had, you know, we didn't have alternate members. And this has been, and I can tell the new members, this has been a wonderful board to serve on. It hasn't been contentious. There's always spirited disagreement and argument that's wonderful. It's the way a board should work. I go to lots of these boards that aren't as healthy as this one, I can tell you that. And very fortunate in Harwich to have had great leadership, and you've all been wonderful friends to me. And maybe someday I'll come back and who knows?
I don't want to, no, you can't sit over there. No.
Not for a year anyway.
I'd like to thank John for all his service. He has been invaluable because he's got the
Here, here.
law. Not only is he got great questions and comments, but he
Great
knows the
insights.
law in this
Yes.
area, and he's been tremendous resource for Gary ahead of me and for me since I've been doing it, because zoning is not my area. I really appreciate all you've done for the board. I think you've really enhanced it through your years of service. I'm gonna miss you, John.
Well, thanks. I miss dealing with it. Believe me, it's with mixed emotions I do this, but I have a plan about retiring and slowing down. You know, I'll be 70 next year, and I decided that I'm not gonna wait. I practiced law with my dad for many years, and he practiced law till he was 88, and the only thing that stopped him was a stroke. I'm not gonna do that. I'm gonna have a little bit more of an organized approach to,
There you go.
you know,
Good
the
for you.
latter part of my life, and so I've got some things on my bucket list. I'm not gonna completely stop practicing law, but
More to life than work.
Yeah, I've already started cutting
Lot
back
more.
on, I'm not taking land court cases anymore, I'm not taking planning board cases, I've already started that kind of thing. I got one land court case to finish up, and I'm done with that. So,
Good for you.
probably close my office up in the Natick area probably in the next 12 months, and just work out of the house here.
That's
Let me
beautiful.
just do this.
Oh, anyway, well, no,
Thank you, John. Okay.
It's been a dream, thank you.
Consistent with past practice, I will be recommending to the Board of Selectmen our longest-serving alternate for a regular position, that's Al Donahue.
Boy, it
Now-
doesn't take long to move up with this
The,
board.
the selectmen might or might not take my recommendation.
You'll be the
but
clerk next meeting.
We have been doing it this way for a long time because we think it keeps our alternates interested and motivated. That's why we let you guys vote in the cases. When we get more cases, I'll alternate. I sit out because I'm running the meeting. I don't need to vote most of the time. Some cases, like the sand pit, I was really interested in, so I wanted to be them in the same way a 40B comes along, but mercifully, only about once every 5 or 6 years. We don't want another one of them, because we had 8 hearings on it. A lot of them were continued, but we had 3 full hearings till 10 or 10:30 at night, and neighbors all in a flurry, and in good. I mean, it didn't get out of hand. Everybody was very well-behaved and made points, but it was kind of an emotional
It was.
series of hearings. For anyone who doesn't know, our town planner, Ellie Sabatino, who's only been here a year, maybe a little more, is leaving to go to Chatham. And one of the other members that I don't know in the building department is also leaving to go to
Jay
Chatham.
Briggs, also, just a beloved and wonderful employee. He was really,
Yeah,
I know. well,
I
he's
don't
gone.
know him. but,
Just a fabulous person.
So we'll
They're
have-
gaining a lot in Chatham.
the second town planner in a couple of years, and they're gonna have to go through the
Why,
search.
do they pay better?
Yep.
They must.
Chatham
They
does.
must. Because we had 2 of them leaving, I mean.
We educate them and off they go.
We're the larger town. That's-
The last point I did speak to, most of you probably read the Chronicle, the selectmen are pushing to get more accessory apartments in town. And they're looking at redoing the bylaw. As you know, we've had half a dozen of them over the years. And they want more rental housing in time. And I saw Ellie the other day, wished her well, and I said, by the way, just for whatever it's worth, we've had like half a dozen cases, and they've never, ever been for a rental. It's always been for family members.
Right.
So I said, I think if the selectmen want to do it, that's fine. I said, I'm not getting involved because it's too political, but just tweaking the present bylaw is not going to do it. So then she asked me, what do you think, should we have any control? And I said, yes, I think we should, because one of the basic principles is 1 house per lot. If you think about it, accessory apartment, if there's no limits, we're gonna have 2 houses per lot, and that could really destroy the character of the town. So I think either the planning board or the Board of Appeals, or both, we would have to do non-conforming lots, and that's the 6 that came before us. And I said, I think there should be some restrictions and limitations on it. Right now, I think it's 2 bedrooms.
It's up to 2 bedrooms, 900 square feet,
Right.
or 1/2 of the area of the
Right,
principal
1/2 of the
house,
principal,
whichever
right.
is smaller. I know because I'm building one.
And the other thing, I said, if they really want to do something, they should get rid of the requirement that new construction has to meet the existing setbacks, because that can't happen on most of the nonconformities. That's why we turn them down every time. They could not meet that requirement on new construction. And most of them, they're not doing it, they don't have the room for renovation, they have to do new construction. Unless they've got a huge lot. So anyway, that's just what's going on there by way of background. I wish everybody a great holiday
One more quick
season.
thing, you asked me about raising the fee for applications.
Oh, yes.
And how we panned out for that. I have I can send it to you, I'll scan it and send it to you. The budget going forward is just gonna be a 2% raise, but it's kind of moved around, so it ends up really being 3.5 in terms of our advertising, because we don't need it in other places, and we'll be fine with that. Our intake far exceeds what we spend.
Oh, okay, that's all that I,
But it sort of absorbs my costs a little bit in terms of my salary for the town and, the cost of our taping and whatever. there are other fees that I don't understand very well. So what we're gonna do is the budget as presented to us, because we don't really get to decide. If you want to think about what you wanna do for next year, we have to plan a little further in advance, but I think we're okay.
I just wanted to know if our intake,
Yep.
was enough to
Yes.
cover the outtake.
Yes, they just
Because
limit,
otherwise
they
we should
limit
raise
our
the fees, but
advertising
if not,
budget
then we'll,
in a way that doesn't make that much sense to me, but we can't really
right,
change
because
it.
John, I think
right
you
now.
said our fees are already on the high side.
Yep.
So,
Yes, they are.
okay, I will entertain a motion to close the hearing. Have a great holiday, everyone, and we'll see you on, right after Christmas, on the 27th, I think, whoever's coming.
It
I'll
is
be
the
here.
27th.
And before the meeting, why don't you do a little poll to see who's coming, and we'll let everybody know how many we have, and
And
then
I'll
you,
have packets ready fairly early.
right. We only need 5, but you're all invited, so more the
Okay.
merrier.
Yeah, would you please
John won't
send
be
me an
here.
email and let me know if you're not coming?
I move that we close the hearing.
Second.
All in favor?
Aye.
Hearing's closed. Thank you all for your patience.
I have something to go out with.
Okay.